Close, don't even start.
All right, welcome back to another day of the Joint Corporations, Elections, and Political Subdivisions Committee. We had a long day yesterday, folks, and really appreciate everyone on the committee, but also appreciate those in the public who stuck with us till the end, and those online who were with us until the end. It was good because it means that today we're going to end at a very reasonable time. So if it's the pleasure of the committee, we'll just power through today. I know we have a 1 hour lunch scheduled, but if we can stay on task and get to that executive orders topic, around noon, then we'll just skip that lunch and get everybody on the road. All right. No objections. With that, let's dive into, we don't need a roll call for the second day necessarily. Okay. Yeah, let's just dive into the Wyoming Department of Insurance. Welcome.
Thank you, Mr. Chairman. Committee members, my name is Jeff Root. I'm the insurance commissioner. Along with me is my deputy, Tana Howard. We have a couple of things on the agenda. If you would like me to just do a brief overview of the agency, I'll be happy to do that, or I can jump right to the topics.
Yeah, go ahead and give us a brief overview of your agency. That'd be fine.
Great. So, Mr. Chairman, our agency is the smallest insurance department in the United States. We have 27 members. We regulate all aspects of insurance. We break down in about 5 sections. We have a financial exams section. We look at all of our domestic insurers, and we get quarterly data from them, and we do an annual report. We want to be sure that they have sufficient reserves to pay claims. We collect yearly premium taxes from them. And every 4 years, we do an in-depth financial exam reviewing how the company operates. With the fees that we collect from the rest of our department and the premium taxes, we bring in approximately $50 million a year to the general fund. That's actually gone up about $10 million in the last 2 to 3 years. And we're a specially funded agency, so we don't cost the state anything. Our next section is the form filing section. All of the policies you see, all of those changes, they go to our office, and we have people that review them to ensure that they conform to Wyoming state law and that they have the proper Wyoming provisions in them. We have a licensing section. We license approximately 1,200 insurers who do business here in Wyoming. We license 3,000 resident agents, but when you when you add to that figure all of the non-resident agents, we're up to about 210,000 agents, people that are authorized to sell insurance in Wyoming, which is an enormous amount. We have consumer support section. Their workload, it sort of ebbs and flows. We have approximately 400 complaints per year, but we help them with many things other than just a complaint. We can explain insurance terms to them, how the process is going to work. And this is where I think our department can really help you if you have contact with a constituent that has an insurance problem. If you'll just forward that to me or our office, we're happy to set them up with an expert. And we may not be able to give them the answer they want to hear, but we can explain the statutes, what the authority is, and what their remedies may very well be. We also have an enforcement action section. This might be against agents, it might be against an insurance company or an agency. We do 40 to 80 actions per year. It's a smaller amount, but they take a lot of time because everyone's afforded administrative due process. So even if there's an out-of-state agent who just stops wanting to be an agent and they don't notify us, we still have to go through the administrative procedures before we take that license. And then we have our odds and ends where we oversee service contracts, the Funeral Home Trust Fund, Wyoming High Risk Insurance Pool, and the Guarantee Association. So the first topic on the agenda, unless there's any questions on what we do or any of that, involves the updating to the Holding Company Systems Act. This is Chapter 44 of Title 26. Most of the changes, most of the things in the changes, we actually do them on an individual basis to an individual insurer. We're now going to apply those things to the larger Holding Company Act. It was first enacted in 1991. We've updated the Holding Company Act in 2013 and 2019, and it currently affects 2 of our insurance companies. So it's just not a notional standard. This is something that actually applies to Wyoming companies. What we're really doing is we want to look at an insurer that's in one of these holding company acts. So you have a holding company act, and then you have other companies below it, and one of them or 2 might be an insurer. We need to look at all those relationships that they have with those other companies within the holding company structure, simply because by the very nature of insurance, they're more liquid than most businesses. They have to have reserves to pay claims, whereas other businesses can do things with their money and tie it up and earn return. And so we want to be sure that those relationships are proper and they're not siphoning off any of the reserves that would be needed to pay claims of consumers. So this update is required for our national accreditation with the NAIC. And the NAIC stands for the National Association of Insurance Commissioners. And I'll just briefly touch on the accreditation portion. Currently, all 50 states and the District of Columbia are accredited. Accreditation really just sets out a consistent standard that helps us and it helps industry, so they know what every state is going to be looking at when we examine them. If a state loses their accreditation, the other states cannot rely upon their work. So we have a domestic company here in Wyoming that does business with the state to the north and with the business to the south. If we lost our accreditation, those states couldn't rely upon our exam, and they would have to either do their own or rely on each other, one of the 2, to do that exam. So once the model is adopted, the standard, it takes, they're given generally a 2-year time frame to implement the new accreditation standards. The standards themselves are created by us, by me, the states. We all get together and we vote on what we think we need to do. And so, for example, after the financial crisis, you look to see, all right, what did we learn from that, and how do we look, and what do we need to see in the future to prevent other problems? So, and lastly, I'll say the accreditation program, it's really a key defense for us against federal intervention. As long as the states are all on the same page and we're doing quality work and everybody can rely upon it, the federal government will not attempt to try to, get into this field. And they have in the past on a couple of occasions tried to regulate something like this. Whereas now we can say, we do it well, and we hold the federal government at bay in that area. So back to the Holding Company Act updates. If I think you have the material in front of you, and I'll just touch a little bit on each area, and if there's questions, please ask. So starting on
Director Rude, we have 2, just so we're all on the same document. We have 2 documents. We have one that's labeled Department of Insurance Cleanup Bill.
Correct, Mr. Chairman, and that is not it.
That's not it. And then we have one that's labeled Department of Insurance Accreditation Bill.
That is it.
That's where we're starting.
I appreciate that.
First bill in your packet, folks.
Yes.
Yes, Representative Ottman. Oh, I suppose.
Thank you, Mr. Chairman. I was just wondering, when you said if we have a financial crisis, we do something to avoid that, or what is that about with insurance?
Director Rude.
Mr. Chairman, Representative Ottman. So for example, when we had the financial housing crisis, you saw a lot of banks, for example, that failed. Well, there really weren't any insurers that failed, but they were affected. So we will look at what happened there and say, what do we need to look at going forward to ensure these companies are better positioned should that happen again?
Okay, thank you.
You're welcome. So starting on page 1, we define group capital calculation instructions, and really the definition of the instructions is the instruction itself and where it can be located. And this is on the NAIC website. Anybody can access it. Looking at XVI, we're adding the definition of the liquidity stress test framework. Again, it's on the website at the NAIC, and so any insurer can look at it and see what the requirements are, what the parameters are. We're defining scope criteria under XVI, which is really just setting out the parameters. So when an insurer looks at this document, it'll say, all right, if you meet these 3 things, then you have to report. That's the scope. And if you don't meet these three things, you don't have to report. So it just sets out who has to do what.
Commissioner Rude, these definitions come directly from the Model Act? Or did you make any
Mr. Chairman,
adjustments to them?
Mr. Chairman, that they come from the web. These definitions are on the website. When you look up, for example, the group capital calculation instructions, you'll pull that up and it'll say for the year 2024, this is the instructions. Now, if something should change, for example, we tweak something, it will be, those companies will have to report that qualify in 2024. But if it changes in 2025, they have to see if they meet the requirements in 2025 to report. If that helps.
That's helpful. Yes.
Okay. So going to page 2, on VII, we're defining third-party consultants. They're going to be referenced later on in the bill, and you'll see that. In the middle section there's a part that's standard, and then we're adding to it. So the definition of materiality is built into the information that insurers comply with when they register. It has to be material for them to submit the information. But that definition of materiality does not apply to the group capital calculations and liquidity stress test. And the way I understand it is, materiality is sort of a term of art legally. It has a threshold to meet. What we're doing here is we're taking this holistic approach and looking, and we really don't want to get wrapped around whether something technically is material or not. If it's important, we want to see it. And so I think that's why it's excluded from this portion of the new language. Continuing on under P, we're setting out that ultimately there's one ultimate controlling person for every insurer that's going to be responsible for this. And the company will tell us who that person is going to be. If for some reason they can't provide the information, they're able to get, they can ask and the lead state commissioner can also grant them the ability for someone else to report it. In these holding company structures, it's possible there's more than one insurance company. And one might be based in Wyoming and one might be based in New Jersey. And so you've got 2 commissioners involved there. The commissioners will decide who's the lead state commissioner taking the role in this. And so there will be one person on each end of this equation who's responsible for carrying it out. Generally, I think it would be the most likely the person whose state has the most business in it, premium wise. So looking to page 3, this is where we list the companies that are going to be exempt from providing this information. And so under I, a holding company that's within a state and that has only one insurer and they write only business in that state, they don't have to provide this information again. The state already has it. So there's no need for them to go through this process. Under II, if the holding company already provides the information to the Federal Reserve Board, they don't have to submit the information again because the lead state can get it from the Federal Reserve Board. Under III, if the holding company system is has a non-US wide supervisor. So let's say it's a multinational company, it's in the United States, but it's being regulated over in the Europe somewhere under the EU. They have the same test requirements that we do. So the company doesn't have to resubmit it, even though it's the same, because it's the same equation that they're applying. So looking at 4, starting on page 3 and going into page 4, there's another holding company example there that's an exception. This one's a little tricky. It's a 2-part, so it's both. If the lead state already has the information, and here's the tricky part, if you have a U.S. company in a foreign jurisdiction that doesn't apply our same standards, if you're with me there, but the company went ahead and did the proper group capital calculation and submitted it, and it's available to the home state. So the home state's still getting it. The lead state is still getting the information. It's just through this circuitous route. Then the company would not have to resubmit the information. So looking at this gives the lead state commissioner they have a little discretion here. If after consulting with potentially other commissioners or supervisors, they have the ability to require the information if they need it. So if a company doesn't under the framework, they don't meet the requirements for reporting, but the lead state still wants it for some reason, they can get it. And then the reverse is true. If the lead state doesn't think they need it, let's say a company is really small and they meet the requirements to file, but the lead state realizes, you know, their market share is so small, it's not going to move the needle on these calculations. Let's not require it of them. They have that option to do. So moving to page 5, if a holding company's system is no longer exempt, so they were exempt, but now they're no longer exempt, they'll have to file, well, they'll have to file in the next annual filing date. And if that date is too soon, they can ask for a delay. Looking on to Q, Q simply means that, you know, if an insurer meets the filing requirements, they need to do it. And they need to provide the information to the lead state for that specific year. And this goes back to the definition. The specific years are going to be very important. You could be required to file the information in 2022, something changes and 2023 kicks in, you may or may not, but for 2022, you've got to file it with the 2022 data. And then if you meet the requirement in 2023, then you do. And if you don't, you don't. So it's going to be year specific. Looking at I, this basically says the NAIC liquidity stress test. It includes the scope criteria for a specific year, like I mentioned. And should that change, if the insurer meets the criteria for the change in that year in the future, they'll have to submit it in that year. So going to page 6, the top half of page 6.
Commissioner, we have a
Yes.
question for you, Senator Landon.
Commissioner, just a quick question. The Financial Stability Task Force, is that housed underneath the National Association of Commissioners?
Mr. Chairman, Senator Leonard, it is. And that's why they slipped the language. If they change it, if it's no longer a task force, it becomes a working group or something like that. It's the same. And that's made up, that's going to be made up of state regulators along with experts from the NAIC who specialize in this area particularly. So I think that puts us onto the top half of page 6. We're talking about the scope criteria to the liquidity stress test and the possible exceptions. So there's an exception when the lead state commissioner, if they consult with this task force and they determine it's not needed. For the example, I mean, for the reason I gave in that past example, that maybe they're just too small a market that they have and it's really not necessary. So, and again, the reverse is true here with if the lead state commissioner after consultation, if they require some submission, it might be some information, but they can request it. Going down to A, this is really a statement of intent that the regulators should avoid making having the insurers fall within the criteria 1 year and out the next. We don't want that back and forth if we can avoid it with that discretion that we have, just because it is, I mean, it's a lot of work on everybody involved. So, and then under II, it starts on page 6 and it goes on to page 7, and it just talks about the importance of the specific year in the liquidity stress test and how, you know, if it applies 1 year, that's the year, the data that they want for that year. And if it changes in the future, you'll reassess for that year. Looking at page 7, this next section applies to confidentiality to the information provided in the analysis. And this is something that's really important, certainly to industry. This is, so under I, the commissioner shall maintain confidentiality of all the reported information, really, dealing with the group capital calculations. And then if you go over to 8, the commissioner shall maintain confidentiality of all the information involving the liquidity stress test and the results there. You'll see we're going to strike out in D either the affiliates and subsidiaries. And on the bottom of page 8, this basically states that there's anyone who gets this information in this process, it's confidential. So if anyone hires a third-party consultant, a consultant or a third-party vendor, there'll be, signed agreements of confidentiality.
Representative Ottman.
Thank you, Mr. Chairman. And please excuse this. This is just for background information for me. But is this Federal Reserve Board for insurance the same Federal Reserve Board for our money?
Mr. Chairman, Representative Ahmed, it's the Federal Reserve Board. Yeah, I think and I don't want to speak out of turn. I'll verify. I believe so, but I am not 100% sure. It's the same title, so I assumed they were the same.
I did not know that they were in charge of insurance.
With the Mr. Chairman, Representative, they're not in charge of insurance, but they have dealings with financial institutions and the regulation of certain aspects of that. And in some insurance companies and in these holding companies, especially when there's might be financial companies within the holding company, there is some overlap.
Okay, thank you.
So let's see, going to okay, so I talked about bottom of page 8 and everybody's agrees it's confidential. Page 9 on the second line, we're taking out affiliates and subsidiaries, and then we're doing that through 3/4 of that page, and we're putting in third-party consultants. And we're really doing that just because it's more accurate, because we're finding out that the states that are involved in this analysis are hiring third-party consultants. So we just wanted to be a little clearer there, I think. Looking at V on the page 9 and going into 10, this states that the NAIC and third-party consultants, they do not maintain the information in a permanent database. That's the commissioner's role. That's who is in charge of the information. And then looking into page 10, if a state does hire a third-party consultant, they're made known to the insurer. So the insurer knows who's looking at their data outside of just the regular state Department of Insurance. So in G, we're adding the third-party consultant language. In H, we're stating that the various tests that I've talked about, liquidity stress test, group capital calculation, those results are tools that the regulators use to assess risk. It's not a racking and stacking of which company is better or worse under this. It's really just a tool for us. It's a method. And that's why I think confidentiality is so important here. It's a tool for us to look into these holding company structures, but we don't want anybody to look at it and make it out to be something more than it's not. So if you're looking at the rest of page 10 and all the way to the end of page 12, we're talking about how publicizing this information is prohibited. And all of page 11 is all of the possible ways it's prohibited. I mean, it goes to ad nauseum, laying out, basically reinforcing that this is confidential information and it should not be released. And if it should be released, the insurer then, if they look at it and they say that's misleading, they can come back to the lead state. They can come back and say, we want portions released to show it's inaccurate. We want to have the opportunity to show that it is inaccurate and it shouldn't, there shouldn't be a negative inference here. So.
Representative Haroldson.
Thank you, Mr. Chairman. Thank you guys for being here today and discussing this. This is a lot. This is a lot. I mean, just even this last page we were just kind of discussing, that is the longest sentence I've ever seen. And I just asked the question, and maybe I was deleting emails or just missed it, but just really bring it back to exactly what is the problem and what is this fix. I understand we're bringing it back up to kind of just a cleanup, and we're bringing it into the more of a modern and kind of addressing some issues. But could you just real quick give me that 30,000 foot view of that real quick for my own sake?
Commissioner Root.
Mr. Chairman.
Yes.
Mr. Chairman, it also might be useful at this time to discuss why we work very hard in the United States to have uniform insurance laws across the country and how it avoids federal intervention in the insurance world. So that might set a stage for some of this too. Thank you, Mr. Chairman.
So, Mr. Chairman, Mr. Co-Chairman, Representative Harrelson, I will do my best, and if I don't do it satisfactorily, bring me around again and I'll try. So we want, these are the standards that we apply to every insurer on their financial examinations. And we want it to be consistent throughout all of the states. Many of these companies operate in different states, and they certainly don't want to have to comply with different standards that vary. Well, that's great for the United States. That keeps the federal government from overseeing it and ensuring that there's some consistency. But we still have a huge insurance market. The bulk of the insurance market is international, and it involves the United States. And so we have reinsurers that are based elsewhere that also are responsible for the insurance markets here in the United States. And just by way of history, the states have always taken sort of an inward approach. We look at, historically, we've always looked at the one insurance company or the 5 insurance companies that are within our jurisdiction, in our state. Europe was doing it differently. They were taking a holistic overview approach and not drilling down to the individual companies. Well, we've understood, I mean, we understand now that we have to have similar standards, and so we're blending the two. So some of this language is long, and you know, for example, our standards in the United States are the same standards in Europe. We want to be sure that these updating of these standards comply with both entities, you know, both the European Union and the United States. So we have these international insurers that will still comfortable doing business here in the United States, and they don't have additional requirements of our American insurers. So the EU can rely upon our work here at home. I hope that helped.
Good, Representative Harrelson?
Thank you, Mr. Chairman. It did. I mean, obviously, I understand that this is a compliance or a uniformity conversation. And with that, I guess the question that I would ask is, so obviously it's 2024 and you're bringing this to us. Have we seen this like mass movement in the United States and other states? Is this a deal we're behind the 8 ball? Is this a situation that we're ahead of the game? Is this a situation that, man, every other state around us has done this and Wyoming just hasn't gotten to it yet? Or kind of, I guess, a little bit of the, I understand the history of the need for it, but where do we stand in that timetable? And is this a situation where there's been 30 other states that have done this and we're going to be 31? Or is this a situation where we're number 5 or number 1 or 50?
Commissioner Root?
So Representative Harrelson, when we come up with an accreditation standard, we have generally 2 years to implement it. 28 states have, we would be 29. There's another group right behind us that are bringing it. So this is the year we just picked. They want it in place in 2026. Don't tell them that, but I think we could probably get a year's grace if we missed it or something, but I'd rather meet the timeline. And that's where we're at. So.
Senator Scott?
Mr. Chairman. On and for the bill. There's quite a history to this. It has served our constituents well, because by having the degree of uniformity we do, we keep the cost of the regulation down, and that reduces the overall cost of insurance. And this one has stood the test of time because it was really tested very severely in the 2008 crash, particularly AIG, where the holding company failed because the feds were regulating it. And the insurance companies survived because the states were regulating them. And that made a big difference, because if the insurance company doesn't survive, number one, you get constituents that can't rely on their insurance. And number two, there are guarantee funds that we're responsible for that wind up paying off, at least in part. So the system has really stood the test of time. This the original bill, which we're amending and not changing the original text very much, we're adding to it to make the regulation work both nationally and internationally, which broadens the market. So again, there's more competition. The original bill dates from 1991. And that was an era when we were first enacting the NAIC. And the state of Wyoming, I don't know about whether it's this law, but a number of the parts of the regulatory standards, the Wyoming State Legislature had a big influence on, because the initial NAIC proposals, I think they paid their attorneys by the pound. And they came in, I remember bringing some of those bills in, and I cut a third of the wordage out. And then Madam Chairman McMillan in the House said, this is way too long and complicated, and sent it back to get it fixed. And that process forced a good deal of change at the NAIC, because we were an early state adopting it. So our predecessors, I say our predecessors, I may well have been the sponsor of the original bill, but
You kind of predate yourself, Charlie.
And Mr.
Yeah.
Chairman, I would have been 5.
but we did have quite an influence on the way this was initially set up. And it's been really very gratifying to see how well it has worked. And I think we have no companies that are going to qualify for this, right?
Mr. Chairman,
Is there
Senator
one?
Scott, we have two
Two.
that applies to, and in the future, I suspect there'll be 2 more that
Okay.
will affect on one end or the other. You
Okay,
can read
so
between the
that-
lines. I don't know. I don't want to say any more than that.
So we're getting some, and having the uniformity sure makes a big difference in how efficient the regulation is applied. And it has stood the test of time. So this is one where I think we can have a good deal of confidence, because the NAIC process has been very thorough. So I guess, Mr. Chairman, my summary is that I strongly urge the committee to let's pass this forward, get it put in Wyoming bill drafting form, and LSO don't change the substance. They really have vetted it well, and it has worked.
Thank you, Senator Scott. Appreciate all your context there too. I think that helps us to understand where we're headed and what we're working on. So appreciate that. Commissioner Root?
Mr. Chairman, that takes
Oh,
us to the end.
Senator
If you
Barlow,
have
did you
more
have a question?
Questions?
Thank you, Mr. Chairman. So are we kind of just general discussion about the bill based on what Senator Scott did? Or are we
Yeah. If you, at
completed
this
with,
point,
I want to make sure the presentation is complete before
I don't think the presentation is quite complete.
okay, so I'll hold.
Okay. Commissioner Root?
Now I'm wondering what I should say for Senator Barlow.
Something profound.
Yes. No, we're really, that's all we have. And just touching on what was brought up about that is the longest sentence I've ever seen without a period. You're right. I think where that comes from is through some of the negotiations with other countries and with the European Union that everybody wants something in. And so you'll see a word in here like supervisor, which we wouldn't normally put in there. That's an odd term. And you look at it as like the supervisor means, the commissioner. It's just referred a little differently. And so we really strongly hope that there aren't any substantive changes to this, because it is a model law that's been agreed upon by the states, and then the states have agreed upon it with, the EU and others. So I will leave it at that, and that's the end of this presentation.
All right, Senator Barlow?
So thank you, Mr. Chairman. So I guess, I think there will be an interesting discussion with LSO drafting it. Page 6, there's not line numbers, but Romanet 8, regulators wish to avoid. I don't know what kind of a statutory construct that has, but anyway, so I think there's some, but my question is, I guess taking a step back, appreciate the history that Senator Scott offered. But it seems like a lot of this could be done through rule, where you can actually adjust as time goes on. And so I'm curious about why we wouldn't give, if they don't already have rulemaking authority, which I'm confident they do in the insurance department, why rule wouldn't be the way to actually implement this without. And actually, when you read this, the more I read it, the more concerned I am about putting this kind of specificity in statute, definitional specificity, when we're actually not defining a whole bunch of stuff. And that's why I wonder if other states are taking a rule-based approach instead of a legislative statutory approach. Thank you, Mr. Chairman.
Go ahead, Senator Landon.
Just to add to that, Mr. Chairman, I was wondering the same thing, and I wondered, I'm kind of looking over toward Josh, who has been through the wars on these insurance statutes. It makes me wonder why we have not referenced national protocols, the National Association of Commissioners. We wouldn't name them formally, but we could refer to that. And that goes to what I think Senator Barlow was pointing to. It just seems to me like this is an awful lot of verbiage to put in the green books when we could simply reference. On a couple of other committees, we've referenced documents or organizations that establish nationwide rules, especially in the world of transportation, for example, and things like that. So, yeah, I had the same question.
Josh, is there a reason why we can't just cite to
Have we
any
ever done that?
NAIC, or do we do that in statute anywhere?
Have we ever done it? Yeah.
Mr. Chairman, certainly we have, done that in places. On the other hand, we often do put this type of thing in statute. Just you don't want, delegation of legislative authority. You don't want to give your lawmaking ability to some other group that could change those rules without being adopted formally by the legislature.
Commissioner Root?
Mr. Chairman, my understanding is the way this has been done in other states and what's been the agreement and how it's gone forward is that these are the statutory changes. There are already other rules out there that we'll use to implement it. And if you, I'll contact the NAIC and see what they think. I'm going to suspect though, they're going to say, well, then you're going to have a rule of 500 pages or something like that. I think the agreements are such that they want it in statute. So you don't have, for example, a state somewhere who on their own just really veers off course and threatens the whole agreed upon structure. So that would be my input.
Mr. Chairman,
Senator Scott?
reinforcing that, I think for exactly the reasons that Josh was explaining, the NIC is very likely to say it has to be in statute or it doesn't count because the statute is stronger than the rule. And you don't have the risk of somebody saying it's an unconstitutional delegation. And I think Josh explained it very well, the underlying reason that I think we're going to see that they're going to insist. And where you've got a whole system that has evolved from being not just the United States, but a bunch of other foreign jurisdictions, which is beneficial to our consultants because our constituents, because it means that you can access insurance from all kinds of places and get more competition and sometimes get specialized insurance you can't otherwise get. I think that's very valuable. So I think I'll predict you that when you investigate, they're going to say it really has to be in statute to count. And yes, we put some odd things in giving guidance, and the I wish phrase is perhaps typical, that sort of thing. But, you're working a compromise with how many jurisdictions do you suppose there are? The 50 US states and God knows how many European countries involved. You're going to see some odd language on occasion. getting something that everybody can agree on.
Commissioner Rude, how often is the Model Holding Company Act updated?
So far, I think it's been about every 4 years. But that's why, for example, when you look at the definitions, the definition of the instructions is the instructions. That's something where they could tweak internally and not have to go back to statute for a change. And if the next financial crisis shows us that there's some relationship between the prime lending rate and maybe foreign bond market, and we need to address it in some way in how we look at these insurers, we would do that in that framework and wouldn't have to make a statutory change. We just make a change in the instruction.
Okay, yeah, that's exactly what I was wondering. Okay. Anything else, committee? Senator Barlow.
Thank you, Mr. Chairman. So I want to understand a little better the drafting instructions from, or the request from the Department of Insurance is this cannot be changed, or there is latitude for our LSO to actually adjust this? Because if we're talking about a compact and we were developing a compact, which there are other compacts out there, I would understand that uniformity, but I can't believe that we can't apply our Wyoming drafting standards and some other things to this and still come out at the same point. So I want to understand if we're going to, we're going to move it forward, right, for a draft, an official draft, but what kind of latitude does our staff actually have to work with this? Thank you, Mr. Chairman.
Commissioner Rude.
Mr. Chairman, I would respectfully request that it be minimal, any latitude. If I'll go ahead and I'll make proper inquiries to the NAIC now and see what they say. I know in the past where there has been, slight latitude, we've gone back and asked them, okay, does this work still? But with this, I know this is of a greater nature, and so from our perspective, I think there's probably less latitude.
Will that be your process? Once we have it in an LSO draft form, will you take it back to them and say, is this sufficient?
Mr. Chairman, yes, I'll send
Okay.
it. I'll send it to the NAIC and have them look at it and see if it meets the requirements.
So if the long sentence becomes 5 sentences,
I am a big believer in periods. If you can't end a sentence without taking 2 or 3 breaths, there's a problem. And so I'm okay with that.
all right. Senator Scott, light up your mic.
Mr. Chairman, that might be an example where we could put the same substance and the same language in and have a 1 little I, 2 little I, 3 little I. That's the way we often do things. And that they might look on as an improvement as long as the language was basically the same.
Yeah, I agree. Anything else, committee? So it sounds like we're moving forward with a bill draft. We've got some latitude, but the leash isn't very long, we as we hear.
Mr. Chairman, I guess one question would be if LSO could propose some of those changes and work with the Department of Insurance on just some of the cleanup and formatting and
Yeah,
have some latitude there.
We'd love it.
we would love to have a almost finished product in August when we see it next. So I think that's a really good idea. All right. What's that? Oh, public comment. Thank you, Representative Yan.
Good morning, Mr. Chairman, members of the committee. Catherine Wilkinson here on behalf of American Property Casualty Insurance Association, standing in support of this bill. It's been well vetted by industry. We've had a chance to participate with that at the NAIC level. We do stand in support of that legislation and would urge you to adopt it to keep it within the state control and for the accreditation standard. It is very important to insurance companies. So, excuse me, I would stand in support and stand for any questions.
Any questions for Ms. Wilkinson? All right, we appreciate you letting us know. Any other public comment? Mr. Red. Welcome to Lander.
Thank you. Good morning, Mr. Chairman, members of the committee. Raymond Red, Blue Cross Blue Shield of Wyoming, and we also stand in support of this bill. It is good to have a uniform bill that moves through the states. It adds a lot of uniformity and takes away a lot of the uncertainty when dealing with other entities. So in dealing with joint ventures and other matters of that nature, it's important to be able to work with another insurance company that may be across state lines in order to have the same sort of field to play in. So I think that the insurance department is making the right move here. We certainly support the bill. And in working with other insurance companies, we prefer the nature of this bill because it does add that uniformity.
Great.
Thank you.
Once we Wyomingize it, let us know if you feel the same way. Any other public comment in the room? Okay, online, if there's any public comment, raise your hand. So we can get you into the room. No hands? No public comment? Okay. All right, I'll officially close public comment, and we did have a discussion to move this information forward into a formal bill draft. Is there any other discussion on that committee?
Well done.
All right, good job. All right. Commissioner Rude,
He was just here.
welcome.
Good to be here, Mr. Chairman. So next up on the agenda is the cleanup bill. So that's the second one that you already have. I'm going to hand it over to Ms. Howard to handle and explain it, walk you through it.
Okay, Mr. Chairman, Tana Howard, Deputy Insurance Commissioner, here to walk through this cleanup bill with you. So a couple of things before we start. This bill has, every couple of years, this committee has really seen a lot of insurance cleanup bills with various things that we've tried to clarify or clean up or correct. And this is really where this comes from. Some of this information has been brought to us by industry, some within our department of issues that we've seen to try to help us regulate our code a little bit better. So starting on page 1, what we are doing here is we have a definition for insurance transaction. Currently, insurance transaction within our code in the definitions applies to insurance support organizations. And what we're doing is we're keeping that definition as it applies to insurance support organizations. We're just moving it up within that subsection to C. And we're creating a new, more broad, cleaner definition of insurance transaction. Insurance transaction is referenced about 12 times within our code. And currently that definition of insurance transaction that's already in the code really only applies to those insurance support organizations. So for example, a situation where we've seen this is in Chapter 9 with it, which is the licensing of agents and consultants. There is a law within that says a producer, so an insurance agent, cannot work in the same insurance transaction as a consultant as well. So we license the producers themselves and the consultants. So this would be an example where we're trying to just clarify what that exactly means when we say an insurance transaction, when they can't work in the same insurance transaction. So again, the definition for insurance transaction stays the same as it applies to the insurance support organizations. And then the definition for insurance transaction starts applying on page 1 and then into page 2, meaning the selling of insurance, the negotiating of insurance, the execution of a contract, any changes to that contract, and really the act of insuring. So just to try to clarify that between the body, but between the regulatory agency, the Department of Insurance, and industry and agents. This is a question that's came up over the past couple of years for us. Moving on to the bottom of page 2, and we're going to see this a lot for the next couple of sections, is it's removing one word, and that word is original. Currently, the Department of Insurance issues a hard copy of a certificate of authority. The certificate of authority for an insurance company is their license. When we license an insurance company, we give them a fancy paper with a gold seal on it that says you're able to do business within the state of Wyoming. Nothing is changing here. We're still issuing a certificate of authority to these companies. We're granting them authority to do business within our state. We're just removing this hard copy requirement. This is also a similar change that we took ahead of this committee a couple years ago with agents themselves. We required the agents to have a hard copy available to the public, and we removed that requirement. It's just updating this code, and this data is real time. Anytime we license an insurance company, it can be verified on our website through the NAIC website. So we're just we're just removing this requirement for this original certificate to be issued, this hard copy. And later on in the code, you see there's an update as well that when an insurance company makes a change to their certificate of authority, or for some reason leaves the state of Wyoming, we require them to return that certificate of authority, that it's property of the state. Many of these insurers have staff changes or are doing business in our state for decades on end. And believe it or not, they lose that one piece of paper. And it can be cumbersome to the department to have them fill out these forms saying they attest to losing it. So we're just trying to modernize this. And that's really what we're doing on page 2 and page 3. Again, just removing this word of original certificate. If a company still wants a hard copy of a certificate of authority, we are happy to grant it for them. We're just removing this original piece. So now we're on page 4. Page 4, again, that the top of that is removing the word original within that 26.3.113. And then we're moving into, we're adding a subsection E. And what this subsection is doing is requiring contact information for insurance companies. We have the same requirement for our agents and entities that are licensed, so we can get a hold of them. These are individuals and companies that we regulate. And currently, we have no requirements for insurance companies to update their contact information. So this is for us to help regulate and help your constituents. For an example in this, if a consumer files a complaint with the Department of Insurance, and for some reason, right, we need to get a hold of this insurance company and investigate what's going on, we would like to have updated contact information so we can serve your constituents faster, better. If we don't have the contact information, it takes time to reach out to these insurance companies to make sure to solve these issues for your consumers. So this is just requiring insurance companies to update their contact information, their phone number, their address, their email, and we would like them to do this within 30 days. This is also the same requirement that we require of the agents within 30 days to update this. And that's what this subsection E is for.
Deputy,
Yes.
this is minor, but why, the way this is designed is the insurance company would need to be aware of the statute, and then it looks like they're going to need to be aware of some type of rule where you point out what the acceptable means of the form of the change is. Why not just specify that? Because I'm assuming you're probably going to be pretty lenient on that. It's going to be sufficient for them to send you an email with the information. Is there a reason why you need latitude to determine the form that's acceptable, or what was your thought there when you put that in statute, in the proposed statute?
Mr. Chairman, the goal of that was a couple of things. If for some reason the contact information changes, for example, when we first started years and years ago regulating insurance companies, that having addresses within the agents, we had to update within our code to include that for email, right, as it progressed and how we contact these. We also do have a couple regulations that reach out specific contact information or situations for these companies within rule. So we were trying to encompass one, address all of the issues for the future in case there's a means of communication that we don't know. And also, this also allows us to say to these insurance companies, the best way to update your contact information if we change databases, for example, or if the NAIC has a different means to update their address, which is they have this online. This addresses that and make sure we don't have to come back to corporations, to the legislature to address how they change that. We can address that within rule.
Okay, that's helpful.
Moving on to the bottom of page 4, which is 263122. And this is in our service of process statutes. Currently, when an insurance company there's a suit against an insurance company that affects that's within an insurer within our state, we are required to, we serve at the Department of Insurance serves as their registered agent or service of process, right? Their attorney, so that we have to be notified. When we receive this notification, we're required to make copies and then notify the insurance company. So we're notified first and then we send it to the insurance company. Currently, within our code, we are required to send this registered mail. We would like to just update this to certified mail. We send all other legal communication via certified mail within our code. We feel like registered mail is maybe a little bit outdated. It's also very expensive to the department. And this is something, we're not sending anything of value within for registered mail. This is just a legal notification. So we feel certified mail is sufficient. We're really looking for notification or confirmation that the insurance company received this communication, and we feel certified mail satisfies that requirement. Moving on to page 5. This is within our rates and forms chapter and within 14. And this is adding a subsection. Couple of things. Where Wyoming is currently the only state that does not have any type of rate regulation or requirement. And this requirement is not rate regulation. I want to make that clear. Where this came about is we had a carrier last year, an insurance company who imposed a significant rate increase. You yourselves probably got some of these calls. I know we got a lot of calls, our department did. And the increase was anywhere from 80% to 200%. And it affected almost 1,000 consumers within the state of Wyoming. Our department was pretty busy, as you can assume, when consumers get such a high rate increase. And we didn't know about this rate increase. We don't have rate regulation. Currently, companies do not have to file their rates. They are not approved. They don't have to notify us anyway. And so what happened when this carrier imposed this large rate increase? Our department felt a little off guard, right? And we want to help the insurance company. We wanted to know, what the reason was for the rate increase and better serve as customer service for your constituents. We want to be able to tell them, this is why. Oh, yes, we've talked to this company, and have an idea of what's happening to our market. So what this is a notification. It's a notification requirement for insurance companies to notify the department and file any rate increase that's going to be 30% or more. I'm sure many of you have received phone calls and emails lately. The market for property casualty insurance is pretty hard. It's pretty tough. Our home and auto insurance is going up for various different reasons all over the country. And this is a better way for our department to keep our finger on the pulse of really know what's happening to our market and why. These rates would be filed just through, or this notification would be filed through an electronic system that we already use for policy forms and filings. There's no charge to file these informational filings. It wouldn't have to be approved. It would just be filed. It's just a notification. And that's really what we're asking within 30 days. Our next,
Yes, Senator Scott.
Mr. Chairman, I want to be very, very clear on this. Right now, I don't think we've ever regulated the rates of the health insurance companies. And I think it was 1983, we deregulated property and casualty. And it worked very well. It's served to hold our rates down. So this is just an information thing. Now, you can still regulate rates if they're uncompetitive. And we have done that, particularly in medical malpractice insurance, Mr. Chairman. I think that's probably been about the only case where we've regulated rates because they were uncompetitive. So this is just information. It's not a first step on a regulation thing. This, and the 30% trigger is what, the level at which you start getting a lot of inquiries?
Deputy Howard?
Mr. Chairman, Senator Scott, yes, that's correct. And this number, I'm sure, you know, industry will have input on this and we're flexible. We feel like this is a good threshold. Nobody wants to see a 30% increase. And we thought maybe this would be a good start, right, for these notifications and hopefully not overly burdensome for the insurers. And to echo Senator Scott's point, yes, this is within Chapter 14. We do not regulate rates, and this is not rate regulation. We do have safeguards in place for non-competitive markets. Yes. So if for some reason our insurance market really drops down to only a few carriers representing or insuring the entirety of the state, we can step in, we can review the rates, we can up, and we would be responsible for approving them. Yes, and we have done that within medical malpractice insurance. I'm thankful that we don't have to do that anymore, but we did that for a number of years. The other rates that we do regulate within health insurance are just Medicare supplement, and then long-term care insurance has to be approved. So those are the only rates that the insurance department reviews or approves.
How did you land on the 30%? Where does that come from?
The 30%, Mr. Chairman, excuse me. The 30% is based off of the consumer complaints we've gotten, really based off of, that's when we see the complaints is when consumers start to get concerned is over that 30% mark. And that's just based off of what we see in our office. It's not something that if there's a better number, then we're definitely, you know, open to it. But that's based on our consumer data. What we've seen is when people start to call.
Interesting. Okay.
Okay. Moving on to the bottom of page 5 and into the top of page 6. A couple of years ago, we took a cleanup bill, again, some updates to Chapter 9, which is our licensing bill. And this is, we made an oops. We forgot to update a couple of references to producer to licensee. So we're just trying to keep that uniformity within Chapter 9 and update those to licensee in lieu of producer. This is not a substantive change. It's just a correction on our part. We missed those 2 references. Moving on to the middle of page 6, within the 2613-201, the committee listened to testimony regarding interim topics regarding fraud reporting, and that Wyoming was one of the very few states that requires mandatory fraud reporting for insurance. As we looked at this bill, or the topics, we thought as a courtesy we would update this and add this requirement within our bill. And what this is just requiring entities to report, it's a mandatory fraud reporting. This fraud reporting, we already are getting these fraud reports. There's an online system through the NEIC. There's an option for these entities to either report it anonymously or name themselves. We get these from companies, we get them from agents, we get them from consumers. And this is just broadening this and requiring the fraud reporting. There's been some discussion among industry that maybe this isn't the best way to go about it. And really, we were just trying to have a courtesy to try to add this within the fraud reporting. And I'm sure you'll hear testimony regarding some maybe added language to this. This definition or this requirement came from NEIC model law. The model within the NAIC is not like the accreditation bill model that we just heard. There's only a few states that have adopted it within its entirety, but we use this language that other states have implemented. At the bottom of page 6 is an update to require business rules and underwriting rules to be filed with the department. Currently, as Commissioner Rude noted earlier, our department requires all policies to be filed with the Department of Insurance and approved. So all of your auto and home health insurance policies have to be filed with the department. Our policy review analysts review them, make sure they're in compliance with Wyoming statute, and then they go to our consumers and the companies for use. What we're seeing is the policy isn't always as transparent as we would like. And we all know insurance is complicated. Some of these contracts, insurance contracts, are very hard to read, and we're not sure exactly how it's being implemented or how the coverage is being applied, because there's a lot of underlining rules that the company applies to make sure that the coverage is applied or the risk is underwritten in a certain way, or for example, the premium is refunded in a certain way. We would just like to review these rules so we can see the full picture of the policy and the policy's intent of exactly how the policy is being applied, and ensure that the policies are truly in compliance with Wyoming law. Again, there's no filing fees in Wyoming. Many states the majority of states already require this. And we just feel like we can get a better picture of transparency to protect Wyoming consumers. Moving on to page 7, there's just one word on this again with going back to that, striking that original within that original certificate of authority, which also carries on to page 8. These are just other parts of within the code, removing that original hard copy document for the certificate of authority for the companies. Moving on to page 9, this again is the original document for the certificate of authority. We're just removing this to make sure that they can still request these certificate of authorities, just not, we're just not required to issue this hard copy and then give it back. In the middle of page 9, we're making an update. This is the clarification that our policy team brought to us, and it's just the scope of what this statute applies. So in 2635, chapter 35 is our non-renewal and cancellation requirements. So if a policy is going to non-renew, or they're going to cancel, or the terms are going to change, we're just clarifying this. We've seen a lot of issues with industry within our policy section that maybe they're interpreting this last line, interpreting that personal lines auto is not included. The department doesn't interpret this statute to exclude personal auto. It just excludes temporary insurance. So when you go and you get a home insurance policy or an auto insurance policy, and it's in place maybe for, the 30 days or maybe the 90 days, those types of policy before it's underwritten and fully executed and issued, the non-renewal and cancellation notification wouldn't apply to a temporary policy, which is, I assume we all kind of understand that. But it would apply to any policy that's in effect. And we're just making sure that it's understood that personal lines auto is also included in that for the notification. Moving on to chapter 10, page 10, excuse me. This is an update that we were brought by our local agent association. The agents mentioned to Commissioner Rood at the good old shrimp bash recently this year that the market is hardening, as we've talked with property and casualty insurance, and having a little more time to help consumers find new insurance when their policies are canceled would be beneficial or helpful. So currently, the notification that is required if a policy is canceled is 45 days, which is pretty in line with most states. The agent association suggested maybe 60. So we're bringing this within our bill to update the notification to consumers from 45 days to 60 when a policy cancels or non-renews.
Mr. Chairman.
First Senator Landon and then Senator Scott.
Thank you, Mr. Chairman. So, thank you for that. And that makes me feel a little more comfortable anytime that we can give some help to our constituents. What do you see come across the desk that causes cancellations? You see that in the statute and it gives you pause. Anybody who has insurance and you think, oh, wow, they can cancel this policy at any time. And even if you have 60 days, that can be problematic. So what causes, can you speak to the cancellation issue for me?
Deputy Howard.
Thank you.
Mr. Chairman, Senator Landon, yes. In this market, and I'm sure there's representatives that here that probably could answer it better since they're in the market. But what we see for complaints and from our consumers is it can be various things. It can be, claims, obviously, a lot of different claims, and that's costing the insurance company thousands and thousands of dollars to where maybe they don't feel like it's a good risk. The market is ever changing, currently now since it's hardening, and we're seeing different companies pull out for different reasons. Wildfire risk, depending if you have cabins maybe or what it might be, different issues related to wildfire or just companies maybe not thinking that certain areas or certain types of insurance are beneficial or, cost effective to them. Insurance companies change what they really want to write and what they feel is profitable to them. And that can change the different, the reasons for cancellation. But typically it can be all sorts of things across the board, but those are some of the most common that we're seeing right now.
All right, Senator Scott.
Chairman, technical question, does this apply to all insurance, or is it just property and casualty, or just health, or is it all kinds?
Deputy Howard.
Mr. Chairman, Senator Scott, this would apply to property casualty insurance. Okay, we're almost through, I swear. We're on the last page here with page 11. And again, this is updating the 45 days to 60 days with a non-renewal notice. And then we have some repeal sections. One of these is, the first is 26.3.113 subsection C, which again is this original certificate of authority for insurance companies. This is exactly that verbiage that I said, if the insurance company leaves or changes, they have to send it back to the Department of Insurance. So we're just removing that. We don't care if you lost their certificate of authority. It's okay. It's not the end of the world. The other two sections came to us from our one domestic health insurer here in Wyoming as a suggestion, and this applies to individual health policies. Wyoming, this is an old law. It's out of date, and this is a requirement for a disclosure within all individual health policies to say this policy includes adult wellness benefits, and adult wellness benefits are those benefits that you get on your health policy that maybe don't apply, that an deductible does not apply to. We see a lot of these now. They're very common. They're required within the Affordable Care Act if you have a policy on the marketplace that's compliant. Wyoming is the only state that requires this disclosure. It causes a lot of confusion for insurers, asking, what is an adult wellness benefit? Why do we have to put this on every policy? This is just repealing that requirement. It doesn't change the policy. It doesn't change anything that these insurance companies are offering and these benefits. These benefits are pretty widely offered nowadays. We're just removing this large disclosure requirement on the policies, and it's repealing that language.
Representative Ottman.
Thank you, Mr. Chairman. I can see that you don't like redundancy, but what I will say is a lot of these policies have different wellness provisions. They offer different things. So how are people supposed to know exactly what is included in their policies if there's not a disclosure?
Deputy Howard.
Mr. Chairman, Representative Ottman, yes. Insurance policies are sometimes hard to read, and that's why our policy analysts are reviewing these. Without the disclosure, it still doesn't change what these benefits are, what benefits are being offered. And our policy analysts review each certificate that's being issued to constituents, right, to the consumers, and the policy language. So they're required by law to make sure that everything that's on that policy is listed. And our policy analysts are reviewing this. So just because it doesn't say on the first page, adult wellness benefits, doesn't change the context of the policy. We still are reviewing every policy to make sure that it's clear to consumers, and that if they are offering these wellness benefits, that it's listed on there and it's clear to say, no deductible applied. And that's how it's generally applied. We're seeing that this disclosure, that a lot of people don't know what the adult wellness benefits really are, and it's just causing more confusion than really help at this point. So within the policy, those benefits are still listed. It's still listed the same. The only thing that this changes is there's a little blurb on the first page that says this policy offers adult wellness benefits. And we're just removing that because it's really, when people get to within the policy contents and that certificate, they didn't even know that that's what they were called, those adult wellness benefits. And so we're still making sure that if those benefits are provided in the policy, that it's clear to consumers. We're just removing the disclosure.
Changing topics on the non-renewal notice, you went from 45 days to 60 days for everyone other than malpractice liability policies, which are 90 days. What is the policy justification for having, I mean, why does everybody else not get 90 days? Because as a consumer, I would love to have more advance notice, but what's the reasoning there?
Yeah, Mr. Chairman, this is going to go back to exactly what Senator Scott was talking about. The 90 days was implemented many years ago when the malpractice market was really tough. We were begging carriers to come into the state of Wyoming to find that coverage for our providers within the state. And so they updated that to 90 days. There's nothing, we thought 60 might be, there's really no state currently for the non-renewal notices that has 90 days. There's one state maybe that has 120. Everything else is within that 30, 45, and there's about 9 states that have 60. So we didn't want to push it to the 90. It's probably a benefit to consumers, like you said, but that 90 days law was written when the medical malpractice insurance was non-existent within the state. We had one carrier at one point, maybe none, and we were begging them to come in there. So that was why.
Thanks. Senator Scott.
Mr. Chairman, on the repealers, you talked to 2 of the 3. What's the third group repealer do?
Yes, Mr. Chairman, Senator Scott, I apologize for not clarifying that. The first one, right, like we talked about, was the certificate of authority and not having to mail that back. The 2 are also in Chapter 18. They both apply to the adult wellness benefit. One is just labeling the adult wellness benefit, and the other is the actual disclosure and what it has to say. Excuse me, I apologize for that.
Committee, any other questions on the cleanup bill? Representative Ottman.
Yes, thank you, Mr. Chairman. And just to go back to that wellness disclosure that I asked you about, that is a lengthy thing. So it's not just a one line that says adult wellness. It requires a signature by the insurer and the insured, and has a lot of definitions. So, I mean, it could just be a lot of verbiage, but it seems like it's a lot just to say it's nothing.
Deputy Howard.
Mr. Chairman, Representative Ottman. Yes, I apologize for that. The intent is that it's really just the disclosure, and that signature goes along with the disclosure of this. It's just outdated language within this that when you apply for an insurance policy, right, whether it's whatever benefits you're getting, you're going to sign a application. And so this is just an added signature, and it's really unnecessary for that. It's saying that when this was created, it was a time when adult wellness benefits, when these wellness benefits that the deductible didn't apply, was really a new concept. It was not something that's offered. And today it's really offered very often. It's pretty common. So when this was created, it was saying, hey, excuse me, you have these benefits and the deductible does not apply. And just so you know, I want you to know that you have these benefits, because this was kind of a new concept of health insurance prior to the Affordable Care Act, prior to qualified health plans. And that was the intent for it, to let consumers know you have these benefits. These are very common right now. So insurance companies are kind of looking at us when we say, hey, they have to file their policies, and every single one of them, it's an objection within our policy form filing saying, we're a Wyoming company and we require this disclosure and we require this signature. And they can't understand why. And we can still keep requiring it, but it really does nothing to those benefits. It's just an added cumbersome. administrative burden maybe to insurance companies and to the policy reviewers who are looking at this, because it's not adding any value right now. It was back when these benefits were a new concept. It was kind of like a flashy headline saying, we have benefits that don't apply, that the deductible doesn't apply. Nowadays, these are pretty common within these policies.
Representative Wiley?
Mr. Chairman, thank you. Deputy Director, have you been working with industry on drafting this bill?
Deputy Howard?
Mr. Chairman, Representative Wiley. Yes, we have several of the repealer language, like I said, did come from Blue Cross Blue Shield of Wyoming. A couple, the non-renewal notices were with local agents through the Insurance Association. Several of the other updates that we've had have also been items that we've seen within our policy review or our consumer complaints. So maybe not directly of saying, for example, like the business rule update requiring the business rules or underwriting rules to be filed. That's something that we deal with every single day within our policy review section, and we're asking for these to make sure we can see a clear view of the policy. But because we don't have statutory authority to ask for these, we're getting pushbacks. We want some clarification. We met with industry last week regarding this bill. I know that they have some concerns, rightfully so. But yes, this is something, an insurance transaction for the definitions. This is something that we've referenced. We've been asked by agents themselves that are dual licensed as producers and consultants, but also within our administrative actions and the legal actions we've taken against producers to ask to clarify. So yes, a lot of this has been worked with industry.
Representative Wiley?
Mr. Chairman, thank you. One more question. Deputy Howard, you had made mention earlier, of some of the states that have different requirements on the days. Well, which state is it that has 120 days?
Deputy Howard?
Got to get my handy dandy spreadsheet. Sorry.
Meantime, we could have a pool for guessing.
Yes.
I guess.
Mr.
We got
Chairman,
Florida. All right.
Senator Case is correct. 120 days, Florida.
Good thing we didn't make any bets there.
I was trying to get some.
Yes, I want to make sure. Florida is the only state currently that has the 120 days for cancellation notice.
Thank you.
It's all those New Yorkers. They talk fast, but they act slow.
It's all those hurricanes.
Yeah, it is.
All right. Thank you, Commissioner Rude and Deputy Howard. We'll move into public comment. Let's hear from the industry.
Been such a friendly morning so far.
It has.
Good morning, Mr. Chairman, members of the committee. Again, Catherine Wilkinson on behalf of American Property Casualty Insurance Association, standing in opposition to this bill. This bill would create substantive changes in the insurance system and add significant new regulatory oversight for insurance companies. We would respectfully suggest that many of the issues in this bill could be addressed without creating new laws, and that the Department of Insurance would need to work with industry to develop these new policies. We did meet with them on Friday, but today is the first day that I'm hearing most of the justifications for these significant policy changes. As of yesterday, the department did reach out to set up quarterly meetings, so we do look forward to visiting with the department on these. We do not feel that any of these changes are needed in the law at this time, but should you decide to move forward with any of these policy changes, we would ask that they be in separate bills, as they are each significant enough that they need public notice to involve industry and other stakeholders in having a thorough discussion to discuss these changes to the industry. because they would add new obligations and costs for insurers. Mr. Chairman, some of the specific sections that we do have concerns with is the definitions. It is greatly broadening those definitions. So we do need to make sure the impacts that those would have. And section 26.3.114, the certificate of authority, within the 30 days of change, we just need to look at that. And in terms of deleting the original, that is probably a cleanup. We'd be fine with that.
Mr. Chairman,
Senator Scott.
that first citation, what page is that on?
Mr. Chairman, the first citation, it's 26.1.102 in the definition. So that would be on page 1. On 26.3.132, Mr. Chairman, if I may continue.
Yes.
Okay, thank you. The certified mail that from registered to certified, we have no problem with that. We would consider that one a cleanup. Mr. Chairman, on 26.14.107 with the filing of rates and the rate changes, Wyoming is currently a no-file state, moving to a notification, even though it's just a notification and not a filing. An approval of rates is still a step towards a more progressive oversight with the industry. And with quarterly meetings or being in touch with the industry, there'll be a better communication between both entities to know what's going on in the insurance market. So while I think certainly the trade associations could probably find language on here and find a level ground, we need to have those communications in order to find what the appropriate manner is, because this implementing this system with filing notices will require insurance companies to change their systems, because that has not been required in Wyoming previously. So this is a big step towards changing those systems. And I'm not saying insurance companies can't get there, but just having a conversation to be aware of that so that those systems can be changed and what the appropriate percentage may be where they're seeing concerns would be appreciated. In terms of the filing new forms, anything that adds concerns the underwriting world is a cause for insurance companies to stand up and pay attention with the underwriting risk, with determining what amount of risk that they need to take on for companies. So that would be a major concern for several companies. In terms of the non-renewal notice and the time frame, I will tell you that most of the states are at 30 days. I know with significant stakeholder input in the state to the south of us, they have just moved to a 45-day with a very thorough review process with all of industry and the department. They understand the concerns there, but again, working with industry and developing the correct time frame for what is needed would be appreciated. So, Mr. Chairman, I think those are some of the last, some of our concerns. I will add with the fraud language, we do have some concern that it is not the model language, that there would need to be some indemnity in there. I believe you will hear about that from another person testifying. But at this time, I think that language, we don't support it as written. It can be tweaked to where we could be supportive of it, but it doesn't include any indemnity at this time. Mr. Chairman, I would stand for any questions and just thank you for your time and thank you.
Senator Scott.
Mr. Chairman, you lost me on that last point as to where it was and what you were objecting to.
26.13.201, the fraud language on page 6.
Mr. Chairman. Mr. Chairman, I believe there are model acts out there that we would be supportive. Again, NAIC with thorough industry input where those have been approved, but you will have further testimony on that. Our biggest objection is there's not indemnity written into any of that language.
Got it, Senator Scott?
I think so.
All right.
Mr. Chairman.
Yes, Co-Chairman, please.
So other states that may have something like this, they have an indemnity clause that's kind of with it.
Mr. Chairman, yes, in any of the other model, I think there's like six model acts or 6 different versions of language. And I believe most of them do include indemnity, but you'll have an expert coming up in a minute.
Okay, so somebody can get us some language. Right.
Yes, there is language out there. Mhm.
Thank you.
Thank you.
Other questions for Ms. Wilkinson? All right. Thanks for kicking it off for us. Now we've got something to think about. Ms. Orr.
Thank you. I had a name change. I'm actually Marion Smith.
I'm
Went back to
sorry.
my maiden name. No, that's okay. I represent the National Insurance Crime Bureau. Thank you for having me here today. I do want to thank the department for taking the initiative of the language that you do see within the changes to the Insurance Act. It does reflect what is in, I'd say probably half of the states. Half of the other states do reference NICB specifically in their statute. We don't believe that that's necessary, as obviously some states don't. But what we do ask is that the indemnification language be included. It's really important that if somebody is reporting fraud, that they not be held liable as for slander or such as that. So I do have a couple, give it to LSO, and I can provide it electronically as well too, but I do have language that is used in other states as well.
Yeah, great. That'd be helpful to have. This language that we're distributing now, where does it come from? You said others.
Yep, other states included. I believe maybe that's Louisiana and Kentucky's. It's all very similar, but we just ask that that language be included as a following paragraph to the language that was suggested by the commission. Pardon me?
It is
Absolutely.
thick
Thank you.
paper.
Thick paper. Insurance business is good.
So what is the highlight? Why do you have some highlighted language on here?
The highlighted language is not necessary.
Okay.
It's, and again, they're really pretty redundant, but just to, again, kind of prove that no insurer, employees or agents of any insurer or any other person acting without malice shall be subject to civil liability of any kind, et cetera.
So there's two different options on here. Is that what it is?
There are.
There's the one at the top and then there's the line across the middle
Yep.
that gives us a second one.
Absolutely. That's all that is.
And what is the distinguishing difference between the two, or?
Really, the only difference is on the second one, it spells out that the National Association of Insurance Commissioners, the Department of Insurance, it holds them immune as well.
I see. Okay. Committee, any questions for Ms. Smith? All right, we'll wrestle with this.
All right.
Thank you.
Thank you. Appreciate your time.
Anyone else make your way to the front?
Big guy's my agent. Don't make him mad, okay?
Good morning. My name is Amy Hendrickson. I'm with the Association of Wyoming Insurance Agents. With me is Tim Robeson, who is an insurance agent here in Lander. And then also online, we have Daniel York, who is a member of our board and an agent in Douglas. We do not at this point have a position on this bill. We are still working through it. There are changes in it that we can support, but there are also some areas that we have a lot of question. One of them is one that just came up to you, which is that section on page 6. We have some concerns and we would support indemnity language. there. But that's really just, I wanted to state our, where we are on this. We look forward to working with the Department of Insurance on some of the questions that we have here. And it's been very informative to be here today to listen to their testimony, and then also the testimony of the Property and Casualty, and also the Crime Bureau. So.
Senator Landon.
Thank you very much. Appreciate you being here this morning. So as I go to page 6, and I think you just referenced 2613-201.
Yes.
Any person engaged in the business of insurance. I'm just curious if you can give me an example of what might cause some heartburn on your part.
With regard to
this side of the dais, it kind of feels like, well, gosh, any one of us, whoever comes across anything that we understand to maybe be fraudulent, we ought to get it reported. So,
Mr. Chair.
Can you help me with that?
Yeah, Ms. Hendrickson.
So the main area that we have a concern is in the language where it says will be. Believe a reasonable, not having knowledge or a reasonable belief that a fraudulent insurance act is being, will be, or has been committed. What if the person reporting is wrong? What happens to that person if they have wrong information? How do you prevent someone who maybe there's some bad feelings and they're just undermining someone that it seems pretty hard to know in advance there. I think ethically they are required as an agent. You are ethically required to report fraud, and they will usually, if they're uncomfortable with an issue, and I'll let my colleague here talk about it, but if there's a concern, they will report it to their within their company already. So, Tim, did you want to say anything?
Tim?
Introduce yourself.
Good morning, Mr. Chairman. My name is Tim Robeson. I'm with Tegler Insurance, and I have an office here in Lander. I guess the language will be is problematic. I mean, it is trying to guess the future. Ethically, if we do come across fraud, we're responsible for reporting that. Typically, that's going to be directly to the carrier. This is also asking us to report directly to the commissioner if we suspect fraud. So I guess that would be in addition to our reporting requirements to the carrier. Carriers also have their fraud teams that will jump on these things as well after we report any issues to them. And those are typically regarding claims or those types of things. So they have whole teams of folks that are trying to crack down on fraud. And as agents, we are on the front line for that already.
Mr. Chairman.
Thank you.
Ms. Hendrickson.
I just would like to make it clear that we are not supporting fraud, that we are certainly against fraud, and we support the reporting or follow-up on concerns with fraud. But this is in statute, and there is some concern. We do have some concerns about as I said, about the trying to determine what's going to happen in the future there.
Mr. Chairman, thank you. That's helpful, and thank goodness we're not against fraud, that's for sure. Or we are against it? Yeah.
Have you reviewed the indemnity language that's been proposed to us?
Mr. Chairman, no, I'm sorry, I have not seen that yet.
Okay, in general, are you more comfortable with this provision if it has an indemnity clause to it, or is the will be something that you're still hung up on?
Yes, I would, I believe that we would be more comfortable with it if there was the indemnity portion there. But again, as I said, our board has not taken a policy position as yet as to whether to support the whole bill or not. So.
Okay, yep. Co-chairman Case.
Thank you, Mr. Chairman. Maybe, do we have an extra copy of this, or people, do we have copies for the room potentially?
Okay.
Yeah, let's, we can share these
Oh.
and appreciate feedback on that.
Whoa, make sure you ask to approach the witness before you.
Wait, Your Honor. Mr. Chairman, you don't have to digest that now. It's kind of long,
Okay.
but it's kind of repetitive in both sense. But my question is more in general about the practical impact. I assume that fraud sometimes is black and white. It's very clear and you're quite confident. But I also assume that there's lots of times that there's a gray area and it's a big gray area. And that may be difficult at some levels to kind of understand that and then know what your obligations are and you're not sure. I see that as kind of being a complication here, and I don't know how it's, you know, you already have that in your business and you have an obligation to your employers and your and I don't know how it works when we take it to the new level with respect to the commissioner and with really that fraud reporting, I think, is going to be it's a social, that information becomes kind of a social good that allows people to understand more about Wyoming markets and particular carriers. And so it's not exactly private and secret. I don't know how it would be revealed, but is the gray area a problem? Tell me about that in practice.
Let me give you an example and.
Better not use my place.
No, let's not use that. Mr. Chairman, Mr. Case. In the insurance industry, and you'll find it in other, well, let's speak specifically regarding, I saw a case recently involving a client. It's called social engineering, where she was called by a third party, and he was trying to get her to pay a whole lot of money, wire a whole lot of money someplace. She didn't know what was going on, and she almost wired a whole bunch of money someplace. And finally she had, and in this case it was a banker, there was enough red flags that the banker stopped it. But in that situation, and I would say that in a lot of situations, you're not necessarily aware immediately of what's going on until you get to the end and you realize, and you look back and you see all the red flags. And so, Mr. Case, there's definitely a lot of gray areas where you may not actually see what's going on until you have a little bit of hindsight.
Yeah, I don't know what we do with that, Mr. Chairman. There's a level of certainty with this language, but immunity is going to be a good idea, I suspect.
Senator Scott.
Mr. Chairman, a couple of things on the indemnity language. As I read it, looking, for instance, at the first option, if this was enacted, they'd have to either prove that you were doing something maliciously, or they would have to prove with the in addition thing that you were knowingly or intentionally communicating false information. So you've raised the standard for what it would take to have a successful lawsuit against somebody for reporting. So, Mr. Chairman, I think that language would make it significantly better in terms of actually getting some reporting, because those are significant protections, Mr. Chairman. I don't see the false information piece in the second half, but I haven't read it carefully yet. The will be language that's on page 6 and right in the middle of that new paragraph. I think there what you're talking about, take the example, if she'd wired it, there would have been a fraud committed, but this was stopped ahead of time. So I think the will be language is harmless there. That's something you see if what's proposed is implemented, then it's going to be fraudulent and going to harm people. So I think that language is all right, and would like a better feeling for the better understanding of what the nature of the complaint about that language was.
Mr. Chairman, if I may.
Go ahead.
The issue with the will be language was just, you know, we don't necessarily know what's going to happen. And so why is the language included in there as a requirement for reporting fraudulent acts? And if I may jump back just a moment, as agents, we do rely on the information that were given to us by clients, potential clients, those types of things. And we do our best to analyze that information. And as an agent, I want to help clients. That's why I live and work here in Lander, Wyoming. We like to think the best of folks. Unfortunately, sometimes people do take advantage of folks. And without indemnity language, as an individual who's trying to help someone, I might get sucked in, even though, you know, we try to analyze everything. We know often when people are not being truthful with us. But sometimes people are really good at not being truthful. And so the indemnity language would help protect us in that regard.
Senator Barlow.
Thank you, Mr. Chairman. So I think what's being pointed out to me is the breadth of that fraudulent language. Because when I read this is you would assume this is being, well, it's written so someone engaged in the business of providing insurance, and then fraudulent insurance act. So now what I'm hearing is if you're if you're issuing policies and you're concerned about your client doing something fraudulent, now you're reporting your own client, not another agent that might be doing something wrong. Something like that. So I think this is far more, I mean, the more I read it, the more I listen, this is far more nuanced than I think maybe we are quite getting with this. We're not talking about one company doing something bad and we're going to report that company. We may be talking about actually your neighbor or your client who you are concerned is potentially doing something fraudulent, defrauding the company, and now you're having to report it to a regulatory agency. And how does that get to a point you used earlier, socialized in a community that this is their insurance provider? Right. So anyway, now I'm starting to understand some of the nuance potentially of what this fraud issue could bring up. Thank you, Mr. Chairman.
Sounds like we figured out it's a little more than a cleanup. All right. Committee, any other questions for Ms. Hendrickson or Mr. Robeson? Yeah, go ahead, Senator Barlow.
Thank you, Mr. Chairman. So I do, on the bottom of page 6, this was the underwriting rule, and that was the underwriting things that was mentioned by Ms. Wilkinson. So as you go back to your organization and then you're talking to the folks that they work with, I mean, you work with underwriters, that would be, I'm curious about how deep that's reaching into third parties, et cetera, when you're in your industry. Thank you.
Mr. Chairman.
Yes.
You know, as I read that language, the insurance contract, it is a contract. And so if there's something that changes the contract, that would be concerning. If I don't necessarily want an underwriting rule to change the contract. And if so, then that needs to be disclosed in some way, shape, or form. So as an agent, we need to know exactly what the policy is. You know, even though Wyoming is a state where the insured is supposed to read their policy, how many of you have actually read your policies? Instead, you're calling on guys like myself to read that and interpret that for you. And so anything that changes the contract needs to be clear.
Senator Scott.
Chairman, is your position then essentially that we ought to not speak of rules or business or underwriting rules that change insurance contract? We ought to say that business or underwriting rules cannot change the contract. That the contract is always what the insurance contract is always what governs.
Mr. Chairman, so this is one of the provisions that we are still working through there. And I would, I mean, given what Tim has said here, Mr. Robeson has said here, I'm not certain we would recommend a language change at this time. We still need to talk with the department and look at what this is more. So I don't think the Association of Wyoming Insurance Agents cannot take a position on that language right at this moment.
All right, thank you. If there's anything else? No? Okay, thank you for your testimony.
Thank you.
Thank you.
Mr. Chairman, we had talked about having a more general discussion of insurance and rates and availability at some point. So I would hope we can get to that, and I hope these guys would stick around for that.
Any other testimony in the room? And then do we have we have one hand up online?
Morning, Mr. Chairman, members of the committee. Raymond Red, Blue Cross Blue Shield of Wyoming. Thanks for allowing us to testify this morning. We agree with several of those that have come up this morning from industry, but we also see the perspective of the Department of Insurance in needing to clean up some things in the statutes. The insurance statutes do have some things that can continue to be cleaned up, I think, from my perspective. I don't know that this is a complete cleanup. There is a lot that probably could be cleaned up, but we don't have a lot of concerns with the movement of this. But I do think that there's a couple provisions that we would have concerns with. And I think the false applications change in 2613-201 has been discussed at length. But I would add that if you look at the NAIC model rule, in addition to this provision, which is mandatory reporting, and the immunity, there's an additional provision for confidentiality. And from my perspective, I think confidentiality is also plays an important role in this, because if you have a mandatory reporting requirement, you would also expect some degree of immunity, but you would probably also expect some degree of confidentiality too. So in some ways, this change is somewhat of a domino effect. And I also, understanding fraud, it's probably one of the highest degrees of conduct that you can prove. It has several elements. And in my understanding of fraud, it would be hard for me to reasonably believe that very many people at all commit fraud because of all the elements that would be required. So the reporting in somebody's mind might be very minimal, but in another person's mind might be higher, depending upon how they look at what fraud actually is in their organization. So I would propose, I didn't bring it with me today, but I would propose that we also consider adding confidentiality from the model rule as well. The civil immunity or the immunity that's discussed here is in that model rule. So it would be very easy to go to that model rule and find the confidentiality provision. And then also for 2615-110, the filing and approval of application forms. Our first read of this, we weren't too concerned. But in thinking about it more and listening to the testimony today, I think we do need to be a bit concerned about this. I'll give you just, a practical example. Health insurance policies are fairly complicated. And in order for us to determine whether someone is eligible for benefits, we do provide benefits for certain things. But there's always caveats. The policy does mostly giveth, but sometimes takes away. And in instances when a medical policy is involved in decision-making, that could be one of these instances where somebody might interpret this language to mean that a medical policy changes the agreement because we say we provide coverage for this particular condition, but if the medical policy says that it's not medically necessary, then we might not cover that condition. And I can tell you that we have hundreds and hundreds and hundreds of medical policies, and they change all the time, sometimes to the benefit of the consumer, which it allows for more benefits, and sometimes to the detriment of the consumer as well. I suppose if, current medical practice says that it wouldn't be medically necessary for a certain particular person. So I think, I'm not saying that the commissioner and the insurance department is asking for something like that, but if they are, it also indicates in here that they would need to be approving those documents too. So I'm not so sure that they would have somebody within their department that could approve a medical policy, or that they would even want to approve a medical policy, since it's literature that's based on standards of care in the medical practice and medical field. So just something to keep in mind. It's definitely something I could see being misinterpreted by somebody and indicating that we should have given the commissioner all these types of things that exist when we do disclose it in the policy itself. And medical necessity is a requirement for us. We have to determine medical necessity under the statutes based on medical literature. But that being said, for the most part, I think we could have some additional discussions on these provisions. We do agree with the repealers, and specifically on the adult wellness benefits. Just for more context on that, I would just add that we don't really call it adult wellness benefits. It's preventative services, which is required by the Affordable Care Act, where you can't impose deductibles and co-insurances on people for who are receiving preventative services. That's required by the Affordable Care Act. And the adult wellness provision applied to policies that were issued after 1999, I believe. So there wouldn't be a policy issued today that wouldn't have preventative services in it anyway. It wouldn't be in compliance with law. So I do support that repeal, and I stand for any questions.
Co-Chairman Case.
Thank you very much. Could we drill down a little bit about the confidentiality
Sure.
piece? So I'm trying to understand who the confidentiality extends to. Is it the person that's making the assertion of fraud or reporting the fraud? That seems kind of like a whistleblower kind of protection. Is it about the nature of the fraud and the individuals or persons are involved in the fraud, who could be, I guess it could be other insurance people, but it certainly is individuals who purchase insurance who commit fraud in that purchase or in receiving claims or pursuing claims under that. If that's confidential, then I'm not sure what good it is to even have the reporting if it can't be used in some way. And I don't really understand how this information would be used, whether it be like reported aggregately, and maybe we're going to have to go back to the department on this. Or is it to say, hey, all you insurance companies, Cale Case is a bad actor in Lander, Wyoming, and avoid him like the plague because he's done all this thing. I don't even understand as the more I think about this and the reporting. So where are we going with the confidentiality and how does that fit in?
Mr. Chairman, Co-Chairman, Senator Case, that is a good question. And in looking at the confidentiality provision in the model rule, it does apply to those materials that are supplied to the commissioner as part of the reporting requirement. So it would require those materials to be kept confidential with respect to the person that is reporting that information and the actual materials. It doesn't mean that that reporting of the fraud can't be chased or taken care of or dealt with. Although there are some caveats in here too, right? So there's some things that the model rule, which we can Wyomingize, I suppose, if we would like to, does allow for the commissioner to do certain things to use that information. And, you know, I would need to go through it a little bit more thoroughly. But in hearing the testimony today, I pulled up the model rule and saw that that was an additional requirement. And just from my perspective, in dealing with these tough issues, if you're levying a fraud accusation against somebody, not only is that a very big deal, it's also something that I think if there is immunity from doing that, it also gives you a little bit greater latitude to do so. And you should feel confident in being able to do that, not only because you have to do it, but because you're expected to do it. And so I think some confidentiality there for you to feel safer in the action that you're taking is probably a very important thing. You don't want that to get out into the press, to get out in there and say, well, geez, you know, all these insurance companies, not only are they doing X, Y, Z, but then they're reporting everybody for fraud, even though that might not be the case. And that might not be exactly what we're doing. We're actually required to report fraud. And so then it just becomes sort of this pattern of, you know, you're doing all these bad things and that kind of thing. So I think it needs to be discussed. It needs to be considered. I'm not saying that absolutely it should be required or it should be required the way the model rule indicates it should be required. But in looking at the standard, fraud is a high standard, but now we're creating a mandatory reporting requirement. And I think in looking at the model rule, they've thought about all the different things that might come into play there. The immunity that was discussed today and the requirement for some confidentiality. I think there needs to be some degree of comfort if you're going to have to do this. So.
More to think about, Mr. Chairman.
Yep, I think so. All right, thank you, Mr. Red.
Thank you, Mr. Chairman.
And then we have someone online. Who's online? Hand up now. Okay. Let's bring Mr. York in just so we can tie that into Ms. Hendrickson's and Mr. Robinson's testimony, and then we'll go to Ms. Agan.
Can the committee hear me
Welcome,
now?
Mr. York.
Great,
We can
thank
hear
you.
now.
My name is Daniel York. I'm a licensed agent in Wyoming. And this may have been, Mr. Chairman, already addressed, at least on some level, but in regards to 2613-201 with the reporting requirements, I feel like there are two sides to this. Certainly the immunity as far as slander goes or something along those lines. But also, I'm concerned about the failure to report. As Mr. Robeson mentioned, there is a aspect of hindsight is 2020, and with the language here, it says that they shall report fraudulent. Definitely a gray area there. And what would the potential repercussions be if there was someone who made the accusation that there was a failure to report? Am I required to be constantly vigilant for that? And if I miss that, then what would the repercussions be? And can the department take action against me, the Department of Insurance take action against a licensed agent for failure to report?
Any questions for Mr. York? Thank you, Mr. York. We appreciate you joining us. All right, we have Miss Agan.
Hello?
Hello, we can hear you.
Oh, great. Great, thank you.
And we can now
very
see
much.
you. Go ahead.
Great, thank you very much, Chairman. So I have two separate concerns slash comments. My first comment is general, but involves everything that's been discussed so far this morning. I wish it wasn't necessary to ask such questions like this, but we are living in crazy times. Does the department have any rules, policies, and or statutes or accreditation requirements for insurance companies to not force their clients to follow ESG rules, guidelines, similar ideologically based or politically based or even religiously based rules or guidelines? People are being debanked all over the world because they hold or have espoused as holding beliefs or have acted upon their beliefs in ways that their banks can agree with. It's only a matter of time before this will be done with insurance policies as well. And in fact, it has already happened. As an example, 2 years ago, the Canadian truckers were protesting mask and vaccine mandates. The Canadian government contacted the banks and the insurance companies of the protesting truckers, the companies the truckers worked for, and those who donated to the truckers. And the Canadian government worked with these banks and insurance companies to shut down the truckers' access to their digital wallets, their bank accounts, and even cancel their insurance policies. What is currently in place and or being worked on by the department and our legislature to ensure that all Wyomings are not treated similarly to the Canadian truckers, for example, but instead fairly, honestly, and properly. And
Miss Agan,
yes,
I'm sorry. I'm sorry to cut you off, but we do need to keep the comments to the scope of what we have addressed. So we're constrained by our own rules on what we can get into with insurance. And right now, what's before us is the Model Holding Company Act, and then this cleanup language that we have, and then the mandatory fraud reporting. Those are the topics that we have in front of us. ESG, while I will agree with you, is a very important subject matter, is not before the committee at this time. So I would ask you to just if you could keep your comments constrained to what the testimony has been today, that would really be appreciated.
thank you, Chairman. I was just finishing up to tie it in, so I will do that. Okay, and what avenues of recourse are available for the department to follow if such bad behavior on the part of insurance companies has occurred? And wouldn't this qualify as a type of fraud?
Oh, I'm sorry. Is that the end of your testimony?
That's my first concern / question, yes.
Okay, go ahead and you said you had another one. Go ahead and give us that one as well.
Okay, so this one's shorter. Thank you. Thank you, Chairman. This one's shorter. So it's kind of similar, but it's different. So my second concern / question is regarding rate increases and policy cancellations. It also incorporates my first concern question regarding potentially insurance companies potentially applying inappropriate conditions upon policies and payouts. How much authority and teeth does the department have to push back on companies that are increasing rates and are canceling policies for reasons that are not related to or suspected to be not related to the conditions or of the insurance policy? And again, wouldn't this be a type of fraud? Thank you very much.
All right. Thank you for your comments, Ms. Agan. Committee, do you have any questions for Ms. Agan? Co-Chairman Case?
Mr. Chairman, I do believe we talked about having a more general discussion of rate landscape and factors driving rates, and I think that'll get to her question when we're done with this bill.
I think you're right on that. So we'll Ms. Agan, I guess, stay with us because we will be talking about rates most likely after we finish up these topics.
Thank you very much. Appreciate it.
Thank you. Anyone else online? All right. Well, that concludes public comment. I do want to circle back to the insurance division, and then we'll talk generally about the information in front of us as well. But right now, let's go ahead and take a 10-minute break, and then we'll come back and we'll take it from there. There's donuts.
You guys know there's donuts over there?
They're delicious. Thank you, Senator Boner, for making sure we were well fed this morning. All right, we are back. And we just concluded public comment. So committee, here's what I'm thinking. There's a couple of different ways we could approach it, but these are some thoughts that Co-Chairman Case and I discussed during the break. And maybe the best way to approach this is we have a cleanup bill in front of us, but we have some provisions that are contentious. Maybe what we do is we put together a bill that is truly cleanup, the true cleanup language from this bill in front of us. We move that forward to our August meeting, and then we carve out the rest of it. Mainly the fraud provision is what we've spent a lot of time talking about, and we get industry and the insurance department together, and they have their kumbaya and come back to us with something that works for everybody. That's kind of what I'm thinking. We could send the whole thing back, but I don't think I think there is some actual true cleanup language that we could develop into a bill if we want to do that. And then we'll end up with 2, maybe 3 bills if we separate all the subjects out. But at the very least, we would have 2 bills. That sounds, everyone on board with that idea? So then what we need to do is, oh, sorry.
Can we get a reaction from the commissioner?
Oh, I thought I saw a head nod.
Okay.
Okay. We're good with that. Industry, does that sound like a good plan? Anyone, no one's obligated to participate, but anyone that has a stake in the game and wants to participate, please get with the department. So then what I have if you have something in your notes, committee, let me know, but what I have LSO to remove from the cleanup bill is 26-14-107, 26-35-203, 26-13-201, and 26-15-110. The changes under those provisions are not considered cleanup. Yes. Yep. 26-14-107, 26-35-203, 26-13-201. That's I believe that one's the fraud one. And then 26-15-110. Representative Harrelson.
Thank you, Mr. Chairman. Just a real quick question on page 1 under that definitions where they struck the old definition and added a new definition. I know there was a little bit of discussion that came up on that one as well under that 26-1-102. Just, and I'm not saying either way, I'm just asking.
I'm getting what do you, Miss Wilkinson? Maybe I just missed that.
Mr. Chairman, members of the committee, Catherine Wilkinson on behalf of APCIA, I think it'd be fine to leave the definition change in the cleanup bill, and we will have comments on that as well, if that works for the committee.
Okay. Yeah, we can always play with it if we have to in August. So let's just take one last look at, make sure we got it all. Senator Scott, please light up your mic.
Excuse me, Mr. Chairman. What I'm going to suggest is that on the stuff that is, you haven't defined as cleanup, that we see if the department can, by the end of June, for the July 4th holiday, get to the LSO staff some language that they can agree on with industry on that, so we can have then LSO put it in proper form for the August meeting, so that we have something specific we can work with. And that'll give them, it isn't ready for prime time yet because they haven't had time to talk to the industry. That'll give them 2 months to do it.
Yep.
And if we set that kind of a deadline and ask them to communicate with the LSO by the end of June.
Sure. I think that gives you enough time. If you need more time, our meeting's not until August 8th. So as long as we get it, we gotta publish our materials obviously 2 weeks before that. So sometime in mid-July at the latest would be, I guess, our goal.
Mr. Chairman, you gotta give LSO enough time to.
Bill draft it.
time to put it in proper
Yeah,
draft.
thank you. That's a good point. Okay,
This will.
sounds good to me.
And they're going to discuss
Committee, anything else on this, or let me double check this bill, make sure we're not. Ms. Wilkinson, did we pull out all the provisions that you at least had highlighted? Yes. Okay. All right, LSO, are we good? We're good? Okay. Any other comments, committee, on this? If not, we'll move into, I think, our general discussion on insurance rates. Mr. Co-Chairman?
Well, Mr. Chairman, I think we said we'd like to have a general discussion about rates and availability and insurance markets in Wyoming. I don't know what members of the committee's experience has been, but the landscape has significantly changed for me and my business. And my agent's right here, and it's like, for property and casualty insurance, it has tripled. I mean, it's just an astounding amount of money. I don't mind sharing it with you. It's like, I used to be able to buy insurance on my whole operations just very recently for like $20,000 was a solid policy. Now I'm more than 3 times that, so $60,000 and $70,000 for insurance. And I don't know if other people are having this same situation. I know my own home insurance has gone up considerably, but nothing like the business. These are concerning to me, and I don't know if you're hearing other stories, or we have constituents, or there are people that maybe the commissioner could fill us in about some of these trends between the two of you. We'd be welcome to hear from you what you think the situation is in Wyoming markets.
Senator Landon?
So while the commissioner's on his way up, Mr. Chairman, yeah, I've had constituents and just me personally, I've seen some impact. So I kind of share the co-chairman's concerns. I'm assuming it's because of all the natural disasters. And I'm assuming that the little population of Wyoming is doing what it can to mitigate all the fire damage out in the west and all of the flood damage down in Florida and all those, but I'm anxious to hear from the commissioner too.
Right,
Mr. Chairman, committee members, Jeff Root, the insurance commissioner. You recall when I first did the agency overview, I told you how we collect an additional 10 million in the last 2 or 3 years. Well, that's because we tax premiums, and that's reflective of premiums going up. And so it's a good news story for more money to go into the state's coffers, but it's coming because we tax insurance companies' premiums, and there's just more of them. I don't think Senator Case's experience is unique to Wyoming from what we discuss on a national level. I think, that's always a topic. There are probably a number of reasons for that, though, but we're very interested in fire coverage, because what we have seen is 20 years ago, properties were rated in a different fire zone formula. Now we've got this urban interface, and now we've got open plains and grass fires. And those are the two things that the Boulder fire and the Panhandle fire in Texas have really emphasized, that your rates can go up now for a fire risk when you don't have a tree in your yard and you may not see one from your back door. We obviously don't have rate authority. We're not seeking that in any way, but we've seen the outcomes, and we've talked with consumers about that. I've made general inquiries with other state commissioners that are of a nature of Maybe it's not the biggest state population wise, but we've got some fire risk. And if there, is there something we can do? And I've talked with the commissioners and we're throwing ideas out could a number of states that are similar to us, lower population, but they do have some higher risks with fire, get together, and could the states come up with, for example, a multi-state pool where, if the talk is, can we get a study done where if we link Wyoming with, other states, Utah, Nevada, South Dakota, and if the state puts in a certain amount of money each, could we then have a reinsurance pool in a certain window to help consumers who have properties in a value of whatever we want that window to be? And the study would help us with that. So they would underwrite certain parts of the cost of that insurance for the window we're looking at. It's just discussions we're having. We're all aware of it. I'm going to a fire summit next week in Boise to talk about this. And so, we've seen what you're feeling, and we're also obviously experiencing it too in our own situation. So I don't know if Ms. Howard has a wonderful background in some of this, and she might have something she wants to add.
Sure, Mr. Chairman, Dana Howard, Deputy Insurance Commissioner. Like Commissioner Rude said, these are things that the NEIC and the national level, all states are looking at. Wyoming is not unique. Unfortunately, we have less population, and we all are pretty close within our state, so we feel it, right? Some of the drivers that we have discussed with other states and with companies of what's really dictating rates are many of what's dictating other markets, right, in other industries, inflation, labor costs. One of the main drivers right now for insurance is reinsurance. And we're seeing a lot of that. Every insurance company, right, property casualty, they have to have reinsurance. They take out their own insurance policy for large claims. And the cost of reinsurance has dramatically increased. So for our insurance companies where we're purchasing insurance, their policies are also going up, which is having a significant impact on the rates. Fire, again, insurance companies are scared, right? We're getting complaints or calls from consumers where it might be a smaller insurance company that maybe isn't as aware with Wyoming landscape or, where our cities and towns are. And a constituent gets maybe canceled and they're in the middle of town. And for different reasons, right? They're not willing to write that risk. It maybe seems more risky because Wyoming is less populated and maybe a little bit obviously more rural. So those are some of the things, and other markets are dictating our market. Obviously, the fires in the other states, the wind, the hail, the natural disasters, large companies are pulling out of different state markets now. We've all read, news articles of different companies pulling out of states like California or whatnot, and they're trying to make up for some of that. And insurance is largely on a big scale, a risk pool, right? We're all in it together, unfortunately, and we're kind of paying the price for some of these other states and other markets. But Wyoming is still, like other markets, we're seeing a little bit less than other states. We haven't maybe hit the brunt of it just yet. It's definitely something we're watching and keeping an eye on. The NEIC is conducting a large data call right now on all property casualty insurers to try to watch this market as well. All of the consumer advocacy groups are also watching these and the trends of where they're really seeing these, different rate increases and price drivers in the property casualty market. I wish I had better answers, and I'll try to do my best.
Senator Scott. Mr. Chairman, remembering a previous discussion from a run-up we had in previous years, and the question was, why are natural disasters elsewhere putting the Wyoming rates up? One of the answers at that point, and I'm wanting to know, is it true this time, is that the insurance companies, and I guess in this case, the reinsurance companies, had lost enough money in those natural disasters that they were unable to write as much insurance because the amount of insurance you can write depends on what you've got in the way of reserves, Mr. Chairman. And that there simply wasn't as much insurance available, so there wasn't much competition because they didn't have the financial reserves to write as much insurance as they used to because they'd lost them in the natural disasters. So I'm wondering, number one, is that a factor? Number two, we do have a special risk in this state with our, particularly our forests and our national forests, because frankly, they're not being managed professionally anymore. They're being managed on the SUM basis, where they can't, the professionals aren't able to harvest as much of the timber on any kind of a regular schedule as they might. And you're seeing a fuels buildup that makes, like the fire we had here in this county a few years ago up by Du Bois, makes that a much more vigorous fire. And so we have a special risk in that area that's shared with a number of the other western states because of the way the federal government has allowed itself to be managed by the lawsuit process in managing the national forests, and we're running extra risks there, and that's a regional problem we need to do something about, and its roots are the national laws. So Mr. Chairman, I'd like the insurance department to comment on those two factors.
I think it's a little bit of a, Mr. Chairman, I think it's a little bit of a stretch to like pin this down on not cleaning up the fuels in the national forest being the reason rates are gone up 3 times, but
well,
let's hear it.
In the fire area.
Commissioner Root.
So, Mr. Chairman, and Senator Scott, to some of your points, we watch reinsurers. We watch where they go, where their money is, and how much money they have. And I think when, for example, you saw inflation go up and the ability to get certain investments, I mean, you could buy a CD at 5% or 5.5%. You hadn't seen that in the last 10 years. A reinsurer will look at that and go, where do we want to try to make our next dollar? Do we want to do it in the bond market where it's 100% certain, or are we going to have more risk in reinsuring P&C policies with wildfire? And I think some of the money is dried up on the reinsurance market. So then that sort of trickles down into your insurers who locally look and they say, wow, we've got a lot of exposure here. We're having a harder time with reinsurance. Let's limit our exposure. And they'll look at a map and they'll say, well, gee, this one is really a cluster. Let's lose some of the risk here. And we can do that through extremely high increases, knowing people will pull out and go elsewhere, and their agents are left with finding them a new policy. And generally they have been able to find new policies, but the increases are there, certainly. We looked at our market to see how many people are writing policies. It's consistent with what we see in South Dakota and North Dakota percentage-wise. We don't have a massive pullout that they saw on the West Coast per se, but that was some of their own doing through overregulation. And I think that's a fair assumption. And I think the commissioner would agree with me in that. And he's learning and adjusting accordingly on that. So I hope that helps a little bit, but we are seeing, like I say, a reduction in risk. And so they don't want it clustered as much, and they want to reduce that. And you can do that by canceling the policy, or you can do it by coming up with really high rates, knowing that some will cancel. And that's what we're seeing.
Mr. Chairman.
Go ahead, Senator Case.
Thank you, Mr. Chairman. And then I suppose we're not saying companies exit the markets, but they're choosing not to insure different types of things, like particular type of business, for example. And frankly, it forces people into surplus lines, and that market just significantly. Do you have any evidence that more and more property and casualty for some businesses is coming out of the surplus lines market, or is there any way to get a handle on that?
Mr. Chairman, yes, we have seen our surplus lines taxes go up within the last few years. It has increased consistently. And I would expect that it will remain that way with the market right now. And that's, again, what we've seen also consistently with other states as well. And you're absolutely right. We have not seen, a mass exodus of companies. And I think that's a good thing. What we have seen, which makes the market hard, is exactly what you're saying, of companies really picking the risks and really drilling down on what type of risk they want to write and what's going to be profitable to them in Wyoming. This is something we've always seen in insurance. When I was an agent, I saw the same thing. And now as a regulator, I see it again from a different angle. Insurance companies are always adjusting what they're going to write and how they're going to write it and how much they're going to charge for that risk. But yes, we're seeing it significant. It's much tighter than it used to be, several years ago. And right, these commercial policies or these home policies, and it depends from company to company. There are companies that are consistently writing homeowners business, within Wyoming, and they're okay with it. And they've maybe pulled out of or really limited their commercial risks. And we've seen companies do the exact opposite, where they're really limiting their homeowner or personal lines risk and they're writing more commercial risk, but again, when they write commercial, it's very limited and what they want to write, and these are people that within the companies of who, and what they write is determined on their actuaries and their profitability and way more, data and drilled down than really I have right now. But those are things that we've seen. Exactly.
And one more, Mr. Chairman. If it's okay.
Yeah, go ahead.
I don't know exactly how to get this point across, but I feel like when you talk to an insurance company and they say, well, because your business has this characteristic, the market is, no one's going to do that. You got to go to surplus line. Are consumers responding by restructuring their companies? I don't know. Imagine a company that has a construction business and they also rent equipment, for example. Okay. And it's all under the same corporate umbrella. And so they apply for insurance, and because of one or the other, it makes them impossible to get insurance in normal lines, and they go to surplus lines. But then are we seeing like companies restructure themselves in a way, and maybe you wouldn't even know this, but to put the rental equipment in a separate business from the construction and actually have a separate corporate organization and seek policy solutions separately? Is that happening? Does that make sense in some cases, or?
Mr. Chairman, Senator Case, that does make sense, and it's interesting. And I don't think we have direct knowledge of it, but I would think that folks here that write policies, that they may see some of that, because that might be ultimately what they do. Instead of insuring one business this way, now we've got two businesses this way and a little bit different focus. But we don't have access to that information.
Okay, thank you.
Yeah, Representative Ottman.
Thank you, Mr. Chairman. Hopefully this goes along with it. But anyway, I wanted to ask, you had said that there was $50 million or $10 million and money goes to the general fund. Is that kept in an insurance designated box for use, or how does that work? And you also said tax on premiums. Is that right? Thank you.
Commissioner Rood.
Mr. Chairman, Representative Ottman. So we collect a premium. There's a premium tax that we calculate. So we go to our insurers and they wrote this much premiums, and we have a tax on it, and it's one of the lowest in the countries for our domestics. And that goes into the general fund. It doesn't fund our operations. It doesn't go into a pot for potential studies or impacts on the insurance market or ways to make the insurance market better. It goes straight into the general fund to do with it as you all will.
Yeah, go ahead, Representative Ottman.
Okay, how was that tax? How was that thought up and implemented? I mean, I didn't do it.
Commissioner Root?
Mr. Chairman, Representative Ottman, every state has a premium tax of some sort. Ours is very, very low. As an inducement to get more domestics here. If we can get more companies domesticated here, that's a good thing for them. What we do have is a reciprocal tax. So if you will, if a company writes a policy here or writes business in Wyoming, but they're based out of Illinois, we get to use the higher Illinois tax on them because they would have used the higher Illinois tax on our company who would write there. So there's this retaliatory provision which benefits the state in that regard. But every state does it. Every state, and it's just a certain percentage calculation that the state determines what they want.
Representative Ottman?
Thank you, Mr. Chairman. And just to clarify that in my mind, so is it a service for providing a service? Is it just all insurances are able to do this, or what is it?
Commissioner Root?
Mr. Chairman, Representative Ottman, it is, if I understand the question, you're asking, what is the premium tax? It is a tax the state places on premiums written by that insurance company. So, okay, so it's a health insurer, it's health premiums. If it's auto, it's auto. If, the general P&C has all of these different premiums they collect for auto and, homeowners and all of that. And it's just a formula.
Representative Knapp?
Thank you, Mr. Chairman. I was just curious to see what your outlook for the future is, and I know that's difficult, but sometimes we forget how interconnected reinsurance is, how banking becomes involved with that. But I can remember back in the day when the UK almost had their banking industry collapse because of insurance and reinsurance. Where do you see the US going? Because there is tightening of capital. There is a commercial real estate collapse almost ready to happen and is currently happening. Do you see that affecting A, the number of companies that survive that, and B, where premiums might go in the future?
Commissioner Root?
Representative Knapp, boy, if I had money to speculate and I knew that, we'd all be in good shape. I think, though, from what our discussions are on a national level, we haven't hit the peak yet. We haven't hit the ceiling yet on increases. I think my best guess would be we're going to still see them in the short run. There's going to be impacts, whether it's the election, it's the prime rate, the foreign bond market affects all of this, things that I would never consider before, but obviously these reinsurers based out of, Austria do. And so I think the collective thought is we're not out of the woods yet. We haven't hit the ceiling yet. As for the number of insurers, it's interesting because Ms. Howard mentioned that, there's always there's always some market somewhere that reduces and another one opens up. We've had roughly the same number of insurers over all lines, whether it's health, whether it's P&C. Consistent, that number's been consistent in the last 15 years because our department is funded through an assessment on them. So we know exactly how many companies there are, and it might waver 20 companies, 10 companies, but it's roughly 1,500, 1,150 to 1,200 every year. So we haven't, had any great drops.
Mr. Chairman, I would just add one thing to Representative Knapp, to kind of pull it back maybe to our original conversation this morning. The NAIC and the states are really watching these types of, impacts on the market. And the bill that we brought originally this morning, the accreditation bill, is really a example of that. And the purpose of that bill is to perform testing on these insurance companies to make sure that they have the capital and liquidity for these significant, maybe financial impacts. In fact, the liquidity stress test that was in the accreditation bill is specific for that. The reason and purpose for it is to test these life insurance companies or whatnot for the liquidity in a financial stressor information, and it was, or event. And so these are things that we're watching, the NEIC is watching, trying to prepare for, right? To make sure these companies remain solvent. It's why we have all of these really stringent and tough financial implement laws on the books for these companies to make sure they survive, and to make sure the states are aware of exactly what's going on.
Committee, anything else? Get your opportunity now to ask the commissioner. No? All right. Anything?
Mr. Chairman, would we allow public comment? or
I think
people-
so.
Yeah, thank
That's
you.
what I was gonna do, yeah.
Thank you very much.
Any
Thank you.
public comment on literally anything in the insurance world at this point? What about online? Senator Barlow?
Thank you, Mr. Chairman. So on the wildfire issue, it's something that's been brought to my attention by various folks. I've spoken to some of the legislators in the western part of the state who have a nexus to the fire fighting, prevent, or fire services. And I'm not going to bring, I might bring it to this committee just as an informational piece if we decide to move something forward. But there are communities on both the east side of the state and the west side of the state, homeowners who are not able to find insurance. Sometimes it's just unaffordable, but sometimes it's not even offered. And so there are becoming some deserts. That has implications in the mortgage market for actually purchasing homes and purchasing things. So there are some implications in there. So I'm not going to try to take on the entire thing or to have look for a programmatic type approach like we have with flood insurance or other things, or federal flood insurance, reinsurance anyway. But there are some other small things that maybe we can do that I'm examining with some other folks. So if something comes to fruition out of those discussions, I'll bring it to the committee for their edification, not because I would particularly want or need the committee to take any action. Thank you, Mr. Chairman.
All right, appreciate that. Yes, Mr. Garrett.
Make sure he's a licensed agent.
Excuse me. Mr. Chairman and members of the committee, my name is Richard Garrett, and I feel compelled to offer some perspective. I've gained so much over the course of the last 8.5. I'm chairman of a coalition called Healthy Wyoming, and I think most of you know that. We've been working very hard for about 10 years to win Medicaid expansion in the state of Wyoming, which is a form of insurance. And to the point that I'm trying to make, we've heard a lot of discussion in the last day or so about how rising costs are impacting your constituents and the people of the state of Wyoming. Respectfully, and I know this is not exactly the right forum for this, but respectfully, I'd like to urge you to open your minds and your hearts once again to how Medicaid expansion could relieve some of this pressure on some of the most vulnerable people that are many of your constituents. I truly appreciate your service and the challenges that you face to do so much on behalf of our beautiful state. But this is something that if you could consider again, I think it would be a big benefit to the people of the state of Wyoming. So I'm a little nervous about saying this in this forum, but I do appreciate your attention and I do appreciate your service too. So,
And I'm a little nervous about asking my committee if they have any questions. That we could blow that 2 o'clock right out of the water, that departure time.
Mr. Chairman, we sure could, but it's a welfare problem, not insurance, so let's not.
All right.
Thank you, Mr. Chairman,
thank you,
and thank you, Senator Scott, too. Okay,
Great.
thanks so much.
Thank you, Mr. Garrett. Any other, public comment?
It's always good to hear from your agent.
Just gonna talk about those tripling rates you have.
Oh, he knows.
Mr. Chairman, Mr. Co-Chairman, Tim Robeson, with Tegler Insurance here in Lander. You know, rising rates do make it difficult to serve our clients. And so these are issues that are very important. Just being on the front lines, we are seeing cases where, and it's important to note that every risk is underwritten on an individual basis. No business is the same. No business has the same loss history. Buildings are built different years. Updates are done at different times to different buildings. There's a lot of different factors that go into it. And it has come to the point sometimes specifically regarding wildfires. This actually started happening a couple of years ago where individuals with properties in the mountains, carriers would non-renew those. And at the time, and it has changed a little bit, at the time, carriers were completely pulling back and saying, no, we don't want to insure these at all. We're starting to see other things that where the insurance industry is evolving just a little bit with things like wildfire deductibles, things like smoke deductibles, things that we've never encountered in the past. That's not necessarily helping with overall affordability, because let's face it, when you're in the middle of a national forest, it's going to be difficult to have affordable insurance. So there's a lot of issues going on in the front lines of the insurance industry right now. And as an agent, we try our best. We do our best to help all those individuals, but it is getting more and more difficult. I've been with Tegler Insurance for 18 years now, and this is the hardest market I've ever seen. Just speaking to various industry folks, to what Mr. Rude pointed out, we don't necessarily see the peak yet. So it's going to be another hard year for insurance. It's difficult, to put it just as simply as I can. And if anyone has questions, I'd be happy to answer them from an agent perspective.
Thank you, Mr. Robeson. We do have a question, Senator Landon.
Mr. Robeson, thank you. Really appreciate you being here. And I don't really have a question. I just want to pass along. I work with some of your colleagues up at the head of the Wind River up in Du Bois, and really appreciate them. And
you bet.
It's nice to have good local insurance agents around. And I hope that if there's anything that this committee can do on the local front, to help, just please keep us in mind and let us know. And thanks for the work you do.
Mr. Chair, Mr. Co-Chair, if I may, thank you for the reminder, Mr. Co-Chair. We've got some things to work on. Just appreciate that. So, and that's part of it too, is just being as an agent, part of our job is to look for solutions. And sometimes it means thinking outside the box on different solutions for our clients. And so appreciate that, Mr. Co-Chair.
Ms. Hendrickson, did you have something to add?
Oh, sorry, I misunderstood you. I thought you said something bad, not something to add.
Oh.
Sorry about that. I have allergies. My ears are all plugged up. No, we really appreciate the conversation, the discussion that's going on here, and the opportunity to be a part of it, and are happy to answer any questions as they come up. Thank you.
Committee, any questions or thoughts? All right, thank you both.
Thank you.
They're good sports.
Any other public comment? Oh, yeah, Mr. York. Welcome back, Mr. York.
Thank you, appreciate it. Mr. Chairman, kind of in response a little bit to what was just stated, I agree with everything. As far as I think we should be considering things that we can do, I think that this committee and even the Department of Insurance has been great on understanding that regulation we are in a very regulated industry. And insurance companies, of course, are very aware of that. And I think that it's important for us all to remember that we want to be careful to maintain that in our state as far as some of the ideas of where we've seen insurance companies struggle a lot is in states where things have gotten out of hand a little bit. Commissioner Rude sort of alluded to that, but just real quick, the thing I think we should think about is our legal environment as a state and maintaining that to the, I don't know if I can say the highest level possible. Tegler is the bulk of our policies are in Wyoming, but we are definitely licensed in many other states. And I see on a regular basis where other states' rates, especially when you're talking about liability, are sometimes in certain industries double what we are seeing. And the reason for that is the legal environment. And if these frivolous lawsuits are allowed to be brought, I'm not exactly sure. This is getting out of my realm, how this can be protected. But when there are claims and there's clear statements by law enforcement that who is at fault, maybe in an auto accident, and there are still lawsuits brought against the person who was stated by the officer on scene that they were not at fault. And it is incredible to me in some of these states how this has been allowed to go on, and it very much affects rates that we see. And then, of course, really sort of going along with that, really making sure that we give our law enforcement all the tools they can have to keep the rule of law very strong and protection, because crime rates, I mean, are definitely what all these insurance companies are looking at as well. But anything we can do to keep the litigation to a reasonable amount to actually protect law-abiding citizens. And then there's the whole area of litigation funding as well, which I'm not really prepared to go into now, but I think it's something that we should be keeping our eye on, and where there is speculation being made in some markets of litigation funding and how people can even make a quick buck on that as well. So tort reform, thinking about those things, and I think all those things will help keep our state really, that we are in a better position than many other states, and considering those as we go ahead.
Thank you, Mr. York. Tort reform might be a good lift for the judiciary, but maybe not for corporations. Looking at Chairman Landon for that one.
Yeah.
Any other public comment? Closing public comment. All right. Anything else, committee?
Appreciated that.
Yeah, that was a good discussion. All right, let's move on to our final topic, executive orders. And Senator Barlow, are you going to introduce this to us?
Morning, Mr. Chairman, members of the committee. Eric Barlow, Senate District 23. So, members of the committee, you will probably note that this was not a topic that was put forth by the committee when you did your interim topic discussion and put those forth to Management Council. This came from Management Council. This is at the behest of Management Council, is added to the interim topics list. So I was willing to at least provide some initial materials and guidance for the chairman for this committee to take this up. It's certainly not, I don't want anyone to perceive, because I'm the one doing this and presenting this, that I have a strong feeling that we should be pursuing something legislatively. Hopefully it will be educational based on the materials that it will be educational, understanding that I think there is a legitimate legislative inquiry to be made about executive orders in general. With the second thing you'll find is a lot of this you will see is based around the sage grouse executive order. And part of the reason that is that that is something that has a considerable public nexus, whether you're in the oil and gas industry or urban developments, subdivisions, agriculture, wind, solar. If you are developing lands that are considered to be habitat of sagebrush habitat, the executive order may influence how you can utilize those lands based on their nexus to a permit or a authorization that the state agency may have. So that's why you're going to see there are many other executive orders that I would argue are purely functions of the executive branch in managing their own affairs. This one tends to be maybe a little broader, and that it impacts many of your constituents and my constituents, and actually me personally. Our ranch lands are in one of these proposed areas. So I have followed the sage grouse executive order since it was first conceived in the Friedenthal administration and the various iterations it has gone through. As many of you know, so I'm trying to give some background, then we'll get into some of the materials. As you know, there's multiple federal actions underway around planning processes around. The sage grouse is one of those. The Rock Springs RMP, of course, got a lot of attention. The sage grouse is also getting a lot of attention. Rock Springs RMP is obviously that area. Sage grouse is statewide, and actually it's multi-state. There's 6 states in that federal action, which we expect a draft EIS out. I would suspect actually in the next weeks, if not month. So there'll be more interest in that. The governor has, we in statute in 2015 implemented the sage grouse implementation team, and also did the credits, the mitigation credit statutory work, I think 2015 and 16. So there is a statutory nexus. What is not in the statutory nexus is the executive order itself, right? The authority or whatever. Now there's going to be, our good former senator, former president, and current chief of staff is here, and he will, of course, will weigh in on behalf of the executive branch. Hopefully he doesn't forget his real roots in the legislative branch. But Mr. Chairman, in the Senate, yes, Mr. Chairman. But anyway, and that's, I certainly respect that they'll have a perspective, but for the purpose of this conversation, I just want to lay that background. That's why the executive, I do not believe we're going to go into, I don't think this is the appropriate place to go into the details of what the executive order, the sage grouse executive order is, or those interactions. We can certainly do that. It's probably for another committee if another committee want to do that. This is more about the process, the actual, et cetera. And if I read, and if I will, if I could, Mr. Chairman, I will read priority 6 so that the committees kind of can recall or have in their mind. The committee will investigate executive orders as it relates to the Wyoming Administrative Procedures Act, including whether executive orders should be incorporated into rule so that there's an opportunity for public comment and seek redress. And then it goes on to talk about sage grouse as an example of how there may be inequities. And we can talk a little bit about that inequities if there's question about them. But that's a component within this particular executive order that has raised some concerns in some communities. It's not generally applied maybe, but in some communities. So, Mr. Chairman, and committees, you've been provided 3 pieces of material. The first one is a memo done by Katie Adams, April 2024. This was actually based on a 2010 memo that Mr. Groover did, and Ms. Adams has updated it. So this is not, I guess the point would be, this is not a new topic. There's been other interest in this in the past. This was an updated memo, and certainly if there are specific questions about that memo and some of the conclusions or the references in there, I will ask you to ask Ms. Adams for those. But there certainly is, if you read this carefully, I think, and I've tried to read it carefully multiple times. Certainly, the Wyoming Supreme Court has opined on the appropriateness and the extent which an executive order can be utilized. You could argue that maybe this U.S. Supreme Court has not done as much of that, but the Wyoming Supreme Court on a couple cases has done that. The second piece is a piece that Ms. Lower did. And actually she did a lot more work, but this is kind of the succession of the sage grouse orders, just so folks kind of know this has been going on. And then other executive orders have kind of had this succession starting in 2007 and going on. And the reason I use that same timeline was because that was the sage grouse, just so people would understand that there are multiple orders that kind of get continued on from one governor to another. And like I said, I'm not suggesting the purpose of these is incorrect. I think the query here, or the charge for us is, should there be a point when executive orders actually go through a rulemaking process or something along those lines? We're going to continue these on for decades, 2007 till today. We're at multiple, not 2 decades, but we're at a certain point in time where, is there a different process that we should at least investigate to say, when it gets to a certain point, how do we, is there a way to do that? The final piece of material that LSO has provided is a bill that did not go through, well, it was introduced, it did not go through the process. It was offered by a now deceased colleague of mine from Campbell County, Representative Sue Wallace. And this is the good old days. Chairman Case was also a co-sponsor on this bill. And it directly was, and you can read the text of the bill, it was in response to sage grouse. This was within 4 years of the initial order. And you can see there's some guidelines laid out about, if you're going to do executive orders, this is how they should be done. So I just throw that out, that this is not a new discussion to at least been broached. It hasn't been fully gone through. We haven't gone through the process. And whether this is the first step, or would be a first step if the committee decides to take it up further. So with that, Mr. Chairman, I think that just summarizes kind of how this came to you, summarize the materials you have before you. And if you want detail on the legal aspect of it, Ms. Adams can provide that. The research aspect, Ms. Kelly, and then Senator Case can talk about his bill draft if he so chooses, which he did not recall when I primed him on it. He said, "I did. I sponsored that bill." So no, co-sponsor, yes. So, Mr. Chairman, I stand for any questions and certainly be glad to go into any details that you might like. Thank you, Mr. Chairman.
Senator Landon has a question for you.
Thank you very much, Mr. Chairman. And Senator, really appreciate you taking the lead to at least lead the discussion a little bit. My question for you is, having served as one of our Wyoming speakers of the House, did you ever run into an occasion where you thought that it would have been helpful, or did it cross your mind that an executive order statute would have been helpful to one of our governors, or a governor that you served with in that capacity? Have you ever run across anything other than the sage grouse initiative that made you think in this direction?
Senator Barlow.
Thank you, Mr. Chairman. I don't know about in my speakership role that I could point to one that would say the legislative branch has some need for understanding or coordination. I would say as a citizen, though, and this is going back to the sage grouse experience and continuing, I think that citizens and my neighbors want to understand a little better how executive orders work and how they influence what they may or may not be able to do with their property or their business, or et cetera. Now, I'm going to be cautious here. I don't know that there are numerous executive orders that do that. And I'm certainly cognizant of Article 2 of the Wyoming Constitution, where they do their job, we do our job. But if that part of that executive order is potentially making law then that is our job. And so if we're making the case of executing the law and doing those things, or managing the affairs of the executive branch, that's certainly within their realm. They can do a policy, they can do, 20 different things. We don't have to call them executive orders if you don't want. You can call them a lot of different things, guidances, et cetera. Executive orders take on a little different level. And then when they start, if they start actually implying law or something like that, then that is something where any legislator, I would think, not just a Speaker of the House, would say, hey, wait a minute, that's in our court. Now let's be clear. We have the Wyoming Administrative Procedures Act, which allows for emergency rulemaking, which is, we got a crisis we got to deal with right now. That can go for 120 days. We can go for another 120 days. I think that's the total 240 days under emergency rules. And then, but in that time frame, and I've been in part of those boards or commissions, particularly the livestock board, where we had a disease outbreak. You had to do something immediately. You had to protect the livestock or the industry, et cetera. So you do something immediate, and then you initiate that formal rulemaking process and go through and get the public input, et cetera. So I guess, Mr. Chairman, a long story to say, I don't know as a speaker, did I feel like is anything, because there is no nexus with executive orders in the legislature right now. But as a citizen and as a legislator, let's make sure we stay in our lane, they stay in their lane. And if there is a conversation to have about, okay, are the lines getting blurred? Then let's understand where that is and have a process to evaluate that. That would be it's not maybe a good enough response, but as a speaker, I never said, damn it, this is really troubling. Now I'm going to caveat that with a little bit. Public health orders are also, but they are specified in statute, and they are given that, and then we've adjusted that in 2 sessions ago. We adjusted that to give it to the executive branch temporarily to a public health officer, and then a longer term to the governor as the chief executive state, or to county commissioners if it's on a county basis. So there's a little caveat that we have addressed it when I was Speaker of the House. It did come up, but that was specific to public health orders, which I would say is a subcategory maybe of executive orders, but they are statutorily authorized. Whereas I think the broader executive orders are not statutorily defined or otherwise, laid out in any process. Thank you, Mr. Chairman.
Representative Harshman.
Thank you, Mr. Chairman. Just on this conversation, not so much executive orders, but I think this balance of power. I think the most recent kind of big case, when my second go as speaker, we were working on a little initiative to really kind of start clawing back some of our legislative branch. But then COVID hit, and then it was President Perkins at that time, and many conversations about how we're going to appropriate COVID dollars. And eventually, you'll remember that the legislature did convene, a short special session to appropriate those dollars. For many states, the governor just spent those as the executive branch saw fit, and we gave pretty broad latitude. But the key is that we gathered together to appropriate and pass that on to the executive branch. So, yeah, and it's a continual thing, and it'll continue. I think capital governance is another one. Just ran out of time on that and a couple other deals, but that's all part of that balance of power. So thank you, Mr. Chairman.
Senator Scott.
Mr. Chairman, my big experience with executive orders has been the sage grouse one, and I share with Senator Barlow, our ranch is almost entirely in sage grouse areas, so it does potentially affect us. And I've got a brother that is on one of the citizens committees that's involved, and my impression has been that sage grouse order has been uniquely successful and been very useful. My question on it is, you have a little different circumstance in the sage grouse in that a couple of the agencies, and I'm thinking specifically of game and fish, but also to a lesser extent, the Oil and Gas Conservation Commission. They're involved in implementing that sage grouse order, but the game and fish in particular is not very directly under the governor's control. It's part of the executive branch, but it is a very independent part of it. And how much do we know how much that influenced the Governor Friedenthal in producing these executive orders in the sage grouse, that he was seeking to get some authority where the whole executive branch was working together on the same page and dealing with an independent agency that he didn't control very well, didn't have legal control over. Is that a factor that makes that order a bit unique?
Mr. Chairman, thank you. So certainly the Chief of Staff can maybe speak to that nexus, the executive branch nexus between the Game and Fish and the governor's office. And probably Mr. Budd is online too. I don't know, Bob Budd. No, okay. Anyway, so Bob Budd has been the common and person involved since that initial Friedenthal era executive order on sage grouse. Now let's be clear to Senator, the good senator's point from Bates Creek is that the sage grouse order was not something Wyoming just said, oh, this is a great idea. We got to do it. It was in response to the potential that the federal government may list the sage grouse as an endangered species, and that listing would impact all facets of Wyoming life when it came to mineral extraction, livestock grazing on federal lands and on private lands with federal nexus, i.e. federal minerals. So there was a significant, that was the impetus for Wyoming taking an active role and generating both this executive order and subsequently legislation that codified the SIGIT and the mitigation credits. So it was a response to try to prevent the worst of the worst, being federal government reaching down into Wyoming saying, oh, by the way, we're going to work on this for you on a wildlife species that we would say we are, we are fully capable of managing and protecting and conserving. And that's what the sage grouse, that's the baseline of where we started. I can't speak to the potential tensions within our executive branch of agency, separate, I'm not coming with the right word, separate operating agency, if you will, or independent agency versus the governor's. We were more concerned about the federal government reaching into any of Wyoming policy and getting into wildlife management, particularly in the sage grouse. So anyway, that's the real nexus. I can't speak to the other, but that's why we have it. That's why we're here. That's why it's important. It is valuable. I think at a certain point, the question I think maybe is, should we actually be maybe codifying it or doing something additional besides just living order to order? Or do we need to be more fluid? Or do we have a rulemaking, with that? That's where I read this as being the charge is. I'm not, and I don't think the charge is we're suggesting that the sage grouse executive order is bad, poor policy. Is it the right process for that policy at a certain point? I hope that maybe helps clarify maybe where management council. So I'll bring out one of the nuances. We can talk about oil and gas, et cetera. There's some nuance in this, and this is one of the reasons Speaker Summers brought this to is in some counties, there are certain types of permits under the Department of Environmental Quality where the county can take over that permitting authority. That it's called small, I wrote it down because it's not something I'm very familiar with. DEQ, small wastewater permits, small wastewater, and a county can actually seek authority that, primacy, if you want to call it, authority from DEQ to actually utilize those. Well, those counties now would not, if those permits are impacted by sage grouse, county is not obligated to an executive order, or not at least in the same way that the DEQ would be, because they are under direct supervision of the executive branch. And so it ends up, and this is what Speaker Summers brought to me, and after I called him up to say, hey, he said there becomes a discrepancy. One county has this authority, one county doesn't. So the constituents in that county are then treated differently because the executive order may be applicable to them, but not to the ones in another county because of that authority that was delegated. So that's one example. I cannot speak to any others because I don't know of any others, but that's one example of just a nuance or a foible, if you will, in application of executive order when there is a potential delegation of authority that would have been impacted. Oil and gas is only the Oil and Gas Conservation Commission is going to deal with oil and gas in the state of Wyoming. Counties are expressly prohibited from doing anything with oil and gas. So there are others where there's no question it's a state role, but there are some, well, one that I'm aware of that there may be some nuance to. Thank you, Mr. Chairman.
Committee, anything else for Senator Barlow? All right, thank you, Senator. Miss Adams or Miss Lower, is there anything you want? We have your materials that you prepared. I'm not sure if you were preparing to give us remarks on them or. Yes,
Mr. Mayor, if I could, I guess when I visited with staff and asked them to kind of update and then prepare some of this, it was basically informational. The committee wants to go further with this. There's further information requests. Certainly, that's the committee's prerogative. And if you have specific questions about anything in the materials, but I didn't ask them. And in fact, I said, don't worry about having to walk through the entire document unless there's specific questions that the committee may have. So I kind of let them off the hook in advance, but certainly if there's specific questions, Mr. Chairman, that's certainly your prerogative. Thank you.
okay. Committee, do you have any questions on the materials for Miss Adams or Miss Lower? No? All right, you are doubly off the hook now. I've blessed Senator Barlow's orders. Mr. Chief of Staff. Thanks for joining us.
Good morning, Mr. Chairman. Drew Perkins, Chief of Staff for Governor Mark Gordon. With respect to Director Bob Budd, I don't know if Bob is online. I think Bob has a very short window today. He has a doctor's appointment that's important to go to that was going to have him. I think he can only be on from like 1 to 1:15. And before that, he was doing a presentation, I believe, at I don't remember if it's the University of Wyoming or somewhere, but he had a presentation he was doing today. I think he had visited with, I don't know if I think he had visited with the good senator and about that. So he might be on at 1, but in visiting with Director Bob Budd, as opposed to Director Lynn Budd, he did, if you want to go into a deep dive on the sage-grouse, he could do that. He suggested, and as I visited with him last night, which was his birthday, yesterday was his birthday, he thought that it would probably, the best way to do that, he probably would take about 2 hours at another meeting to get, if you want to go in a deep dive on that. And obviously, Director Budd has been instrumental in the implementation, the drafting of all the sage-grouse policies. With respect to the sage-grouse and EOs in general, I think if you look at where you're at with executive orders, just a couple of brief comments. A couple things I would do with respect to Governor Gordon. I can tell you that Governor Gordon's issued 33 executive orders since he took office in 2019. 23 of those have been emergency orders of one sort or another. The big year was obviously 2020 with COVID, and about half of those emergency orders were trying to get the emergency bar and grill, food service for curbside and food service, trying to get those right and make sure that those were right. Different staffing orders. Another order that comes up every year, at least, I think there's at least 2 a year, comes with respect to delivery of propane and other fuel heating sources. Propane, fuel oil or others in some cases, there's not enough trucks and cold weather may input those. And so under the federal law, he can do an executive order for up to 30 days so that to relieve them of some of the driving requirements, the hours that truck drivers can drive so that they can deliver, in particular, residential heating oil during winter or propane. There's been several where the federal law also gives governors the ability to do executive orders with respect to delivering baled livestock feed and limiting, again, permissive hours or also weight restrictions, which he has done numerous times. So those are the number of executive orders he gave. He did three executive orders in his first year. Then COVID year, nine in 2020, 9 in 2021, 5 in 2022, 3 last year, and he's done 4 so far this year. Those, like I say, all those together, 23 are emergency orders. The others are responses to federal action or threatened federal action. 4 of those were with respect to sage grouse action that the Secretary of Interior had proposed with both an presidential executive order as well as a secretary's order, and also with when the cessation of oil and gas drilling on federal lands in Wyoming. He did a couple of orders that required the Attorney General and every agency to go and look at every available means to go and enforce that. And as you know, that the state of Wyoming successfully sued the federal government, and they've started to resume those, although they are very good at dragging their feet. And then there's been the remaining executive orders that Governor Gordon has issued since in his time as office, been 6 orders that are just basically executive branch reorganizations. The biggest one being the HRD consolidation a number of years ago, and the others are things like he created the healthcare task force and some things like that. And so those are the main ones that he's done. As I've gone back and looked at the executive orders, I think it's a couple things. The question is, where does the power from executive order comes from? Where does that arise from? This is addressed somewhat in the memo, but just to take you through it really quickly, Article 4, first of all, you get to, as I think as the good Chairman Harshman, not chairman of this committee, but Representative Harshman in this committee, referred to Article 2, which is separation of powers, that everybody's got their job to do in the 3 branches of government. From there, you go to Article 4, Section 1, which requires that the executive power be vested in a governor. And so that's a grant of there's what's called executive power. That is further, that's expanded a little bit upon in Section 4 of Article 4, the Wyoming Constitution. The governor is the commander-in-chief and talks about his powers of the as military forces of the state, except when they are called into service by the United States, and may call out the same to execute laws, suppress insurrection, repel invasion. It goes down through, again, talking his duties to call out or call into each legislative session, communicate with the legislature by message and things. But the last sentence in Section 4 says that he shall transact all necessary business with the officers of the government, civil and military. He shall expedite all such measures as may be resolved by the legislature, and shall take care that all laws be faithfully executed. So the 2 things that you find when you start to research these things is grant of executive power in Section 1, and then this requirement that he shall take care that all laws be faithfully executed in Section 4. There's also, I think, that you should take of note that when you go to Article 4, Section 12, that this, I think, also underscores indirectly that the governor's inherent powers as the chief executive are different than the other state electeds. Article 12 provides that the powers and duties of the Secretary of State, the state auditor, the treasurer, and the superintendent of public instruction shall be prescribed by law. You'll notice that the governor's excluded from that particular provision of the Constitution. Other explicit recognition of the power of the executive in the Constitution includes pardons, commutations, and reprieves, which are basically recognized in the Constitution as various forms of executive power, which each and of their own is there a difference between a proclamation and an executive order. that may be debatable, but they're all examples of executive power. They're specifically proclamations mentioned in the Constitution, as are vetoes and as are filling certain vacancies. And then there's also a very interesting recognition by the legislature in Wyoming Statute 9-1-201, which states as follows: in accordance with Wyoming Constitution, the governor is the chief executive officer of the state of Wyoming. The governor shall formulate and administer the policies of and shall exercise general supervision, direction, and control over the executive branch of state government. The governor shall have the authority to obtain criminal background histories and some other things like that. But the main thing is this: even the legislature very early on recognized that the power of this chief executive arises out of the Constitution, and that he had all of those. So the supervision, direction, control of the executive branch of state government. Early on, and just two other things I'll bring in this general discussion. There are two cases that happened. They're both in 1893, so just 3 years after statehood. 1893. The first one is Richard versus Henderson, and there's a statement in there that the Wyoming Supreme Court made, that the power of the executive and judicial departments is a grant, not a limitation, except as restricted and limited by the Constitution, which the people have adopted. And so then the other case is called Miller versus Barber, which was actually a lawsuit between the Secretary of State and the governor about who had the right to whether or not the Secretary of State could withhold a stamp on the appointment of the fish commissioner in 1893. And the court said in as follows: in short, he is the governor of the state, placed in his position by the people of the state, and authorized by the constitutional laws of the state to perform certain acts, and acting as he does under the sanction of a solemn oath. His official acts are entitled to the respect of everyone, because they are the acts of the proper department and are prima facie are presumed to be within the power and authority conferred upon him by law. And so there's this general grant of power. If you go into some things like Corpus Juris Secundum, which is kind of a legal encyclopedia, it talks about some of these things and recognizes that's kind of where, because there are many states do not expressly give the governors the express authority to issue executive orders in their constitution. With respect to the sage grouse and a couple of points that were brought up, I think that in looking at that, the sage grouse EO, as the good senator from Campbell County mentioned, was originally done in 2007, was in direct response to action by the U.S. government to list sage grouse was endangered. They wanted to list the sage grouse. I think if most of us think back, we recognize what a problem that is to the state of Wyoming if indeed the bird was listed. And so 2007 happened. Governor Friedenthal put it together. Director Budd was heavily involved in that. And so ultimately that was, and then in the subsequent actions taken to amend the executive orders amended by Governor Meade and then subsequently amended fairly early on by Governor Gordon as well, that has been able to the bird is still not listed, right? And so there is another action that is anticipated to be, it's been filed or is filed soon. Again, revisiting sage grouse. I think, I think the wolf, again, if you look at the wolf issue, I believe that was filed last week, again, in Missoula, Montana, because that's where they've been successful before. And of course, we've been trying to have the grizzly bear delisted for some time with supportive agencies, but that also continues to go through the legal process. But I think it's important to note that as the good senator mentioned before, that the executive order is very, very successful in implementing the sage grouse plan, and has, in fact, from there, working with other states, you now have multiple states that have adopted very, very similar orders, either in statute or by executive order in those other states to do the same thing. And that's been very successful in keeping the bird from being listed. I think it's also noticed, as the good senator also mentioned, that particular order has now been in effect in one form or another for 17 years. It's important to note that even in these instances, the legislature could have acted and can act to codify or otherwise take and exert its legislative authority with respect to those orders, or with respect to pretty much almost any executive order that the governor issues. The legislature can undertake and go and about its business and determine whether there's the legislature should act in an area where the legislature has not acted and the governor has, are free to do that at any point in time. That is one of the duties and directions and authorities that the legislature has. The legislature has done several overt acts. Again, these have been mentioned to you in recognizing and basically adopting or following the governor's executive orders on sage grouse. Those have already been mentioned. They in a number of years ago, they implemented the sage grouse implementation team, which is now statutory advice. And so there's been given certain authorities and direction to the sage grouse implementation team with respect to implementing those orders. In addition to that, they've also, as an enhanced that, provided for the mitigation credits, and other things like that with respect to adopting and further enforcing those orders. So there's examples where the legislature has not overridden the order with legislation, but has supported the order with legislation. So again, I think that you'll find that this has been a back and forth, and this is in large part I think branches working together, recognizing that in many instances they're working on the margins of their separation of power. And is there and will there be times when one branch or the other oversteps in separations? Obviously so. How many times have we talked about in our ongoing civics lessons that we have in the administration of government in all the branches of government about the healthy tension between the branches. And so as we talk about that, a couple of other things I would mention with respect to sage grouse is that with respect to sage grouse implementation, the executive order was written very directly and said that agencies could only exercise the power to which they had been granted by the legislature. And so they were only directed to act within their statutorily derived powers in putting forth the sage grouse executive order and doing that. There's a couple of other things that I think statutory policies that have been implemented and recognized by the Wyoming legislature that also support those types of efforts. I think you again find those there's also been an executive order with respect to migration corridors for game, for particularly antelope and deer. But those two policies are one primacy. We've always insisted that Wyoming should take care of its own wildlife. That's provision. We have the expertise, we have the ability, we have the connection to our wildlife to manage our own wildlife. So that idea of maintaining primacy over our wildlife is a shared value and one that's been enunciated numerous times by the legislature in various forms. Another policy that's been enumerated and put forth by the legislature that also supports the sage grouse executive order, at least until the legislature would take a legislative action to supersede that, is the loss of open spaces. There has been, and many of you were in the legislature when we worked on bills that limited the fractionalization of large swaths. Think about, particularly in Natrona County, Beaver Brooks Ranch, where you had large ranches and we're dividing them up into 40 and 20 acre subdivisions, which have dramatic effects, not only on wildlife, whether they're listed or not listed, whether endangered or endangered, but about the very way of life. We have the same things we see with both transmission lines, with wind towers, with other developments. We have those with industrial siding. There's all those types of things where we have to, if we're going to keep the Wyoming that we love, to maintain and protect habitat, view sheds, and other values, which are shared values between all the branches of government, but which this body, the legislature has done numerous times. So another thing I would say with respect to the sage-grouse implementation rule, also with respect to, and this touches on the role of game and fish, and then the other agency was largely affected by the sage-grouse executive order, is the game and fish, and then the OGCC. So game and fish, as has been pointed out, is under independent control of the commission, and so they do some rulemaking, but they do a lot of research. They do other things to support sage-grouse, and certainly provide and control that as a game species and as a wildlife species. They have that control, and so basically, as the executive order was unable to specifically direct game and fish to do anything directly, but just encourage them to do what they could to implement, and fortunately, there's always been, at least since the sage-grouse EO, that you find the commission and the governor's office in lockstep pretty much with respect to management of that species. With respect to Oil and Gas Commission, when those directions came out, there's also rules and other things that then the OGC promulgated with respect to implementing these rules. Those rules, and particularly in the OGCC, if there was an aggrieved party who was affected or aggrieved by a final agency determination, of which the Oil and Gas Commission is an agency determination. So if there was a landowner or another person who was affected by an order or determination made by the OGCC, they were available for two things. One, you could have under the APA, the Administrative Procedures Act, they could challenge that, and you could have an administrative hearing on that final determination issued by the OGCC. There's also the ability to have, if you exhaust administrative appeal, or in other instances, you can always challenge the executive order by judicial review, either one as an appeal from a final determination by an agency, or you're always free, or an aggrieved party is always free to challenge an executive order, whether it's the sage-grouse EO or a different executive order, is always free to challenge that based upon whether or not the governor has exceeded his authority in issuing the executive order. And so there are already existing a number of ways with respect to challenge executive orders, particularly as they're implemented. I think the only other thing I would mention with respect to executive orders are a couple things that you, as you look at this, that you might consider. There's a couple really simple things that you also might do that might help with this. One is that in providing for particularly livestock orders, there's a number of instances where statutes and livestock is one of them, where the legislature has given the governor ability to establish executive orders. You find it very common in almost all the compact states. There's a recognition that regulation, a law, a statute, or an executive order, other action that has the force and effect of law, then is recognized that may affect and may implement, may put you in line with, or actually take you out of compliance with the compact to which you've agreed in a compact. You also find them consistently in the livestock. The Livestock Board does provide for a number of orders that happen with respect to both federal law and state law that provides the governor the ability to issue executive orders in certain instances, particularly in emergency situations where there's outbreaks with respect to communicable diseases, brucellosis, or other things, that there's some power given the governor to take some initial action as well. And then, but one of the things that is probably very fixable with respect to executive orders is, where do you find executive orders? You can find every executive order Governor Gordon has issued on his website, but where do you find the rest of them? You find them filed at the state library, but it's a little bit of a chore to find them on the state library. You have to go into the state library, you go try this at their YCAT system, you go to the YCAT system, then you go to government documents, then you go to orders, and they'll come up and you can find every executive order that has not been listed. Why are they on the state library's website? Because there's no place in statute that requires the Secretary of State or anybody else to file those and do those. So one very very simple thing that would happen that would help the transparency with respect to executive orders would be simply to command the Secretary of State to take them filed just as you would rules or other things so that people could find them. But that charge has not been given to the Secretary of State in statute. Therefore, that's why they're at the state hospital. So with respect to that, I don't know that I have much more to say about it. I am happy to answer any questions or have that discussion. I am certainly not the expert on the sage-grouse EO. Again, if you want to go in that in any depth, Director Budd is I think is a regionally, if not nationally recognized expert on the subject. And talking with him yesterday, if you really want to go into that, he could do a presentation, but he thinks the presentation would probably take an hour and probably would engender probably an hour of discussion and public comment if you did that in a future meeting. That, Mr. Chairman, would conclude my remarks, and I stand ready to answer any questions that you might have.
Well, Chief Perkins, as I understand it, since you mentioned his name, he's appeared on Zoom now. He's there, but
Okay.
he hasn't come into our room yet, but he is watching us now. So is he? Okay. So maybe we'll go to him next,
Let's not get the 2-hour version.
but we'll take the truncated version. Do you have any questions for Chief Perkins? I'm just curious on this old House bill that's resurrected, House Bill 55. Have you looked at it?
No, I haven't.
Okay, I was going to ask you if you had feelings or thoughts on some of it, but it does create the registry in the Secretary of State's office. So that's one of the things you mentioned that we could possibly take action on, but it's a lot more substantive than that as well. So, but I won't ask you about it if you haven't read it.
You know, what I can do is if I know that Director Budd has limited time today, if we want to go to him, we can come back and we can visit some more if we finish with him or if he has to leave.
Okay, that sounds perfect. All right. Welcome, Mr. Budd.
Thank you, Mr. Chairman. Good morning, members of the committee. My time, actually, you're moving ahead of schedule, and I've been watching this morning, so my time is not an issue, but I don't think I need much time. I think by way of background, what I would share with you, and Chief Perkins has already made it quite clear, I'm happy to come and walk through the entire history of our executive order, as well as Nevada's, Utah's, Montana's, Idaho's. We help facilitate all of those. But you have to remember at the point in time that there was an imminent threat of sage grouse being listed as an endangered species. It was warranted but precluded at the time. There were no actions that had been taken on federal lands to deal with management. And so the state stepped into that to say, we have the ability and the authority, wildlife being the property of the state, to do that. And at that time, there were numerous people who came and said, this should be done statutorily, this should be done through rule, this should be done 10, 12 different ways. If you think about it, to do a technical order, which is extremely deep in science, the situation called for either getting 30-some state agencies to adopt the same rule in a timely manner, which I think you can understand was not a likely possibility, or 90 people on the floor of the legislature coming to terms with scientific and conservation practices that were fairly well established. So the executive order route is what was chosen by Governor Freudenthal. And as Chief Perkins mentioned, over time, numerous pieces of that have actually been incorporated both in rule and in statute. The first entity to adopt a rule relative to sage grouse was the state land board, and that was done in 2008. Other agencies have adopted rules, but most have just relied on the directive from the executive branch to operate their way. I think where some of the concern today comes from is exactly what was described, which is you have different counties interpreting different portions of that executive order or not interpreting it at all. And consequently, your playing field could be viewed as not being level. That certainly has played out in the subdivision arena. It's pretty uniform in oil and gas. It's uniform in mining. It's uniform with regard to roads and those kind of things. The one area that remains unregulated for a large part is rural subdivision. And so that's where I think this came to a head. And I've had numerous conversations with Speaker Summers about that issue and how it affects Sublette County vis-a-vis how it might affect Carbon County. So that is kind of where we are. The reason it was done by executive order, I think, is pretty clear. I think you can all understand that that was the only real way that we could address the issue. In the end, we have gone now for 18 years without a listing of that species. As was pointed out by Senator Barlow, we are going through another sage grouse amendment, and certainly in a different set of circumstances. If you look at the administrations we've dealt with, we started this in the Bush administration, went through the Obama administration, the Trump administration, and now we're in the Biden. And each of those comes in and can take different approaches, many of which we don't agree with. And we're going through that process as we speak. We're in the 90-day comment period on the draft EIS for sage grouse. Throw on top of that, I know why people have consternation. You just need to take a look at the Rock Springs plan or the recently issued conservation rule. There are many, many things that interface here. The one thing I would say is that for that 18-year period, 17, 18 years, the sage grouse order has stood the test of time, and it stood the test of biology and legal challenges. So certainly no objection to the legislature taking a deep dive and looking at how we can improve it. Areas, as you've already done, that the legislature would like to weigh in, as you have by creating the SIGIT and by making a statement and setting a standard for mitigation, which frankly is the best one in the country. But I'd be happy to answer any questions, Mr. Chairman, if you have them.
Committee questions for Mr. Budd? All right, thank you. We appreciate that. Chief Perkins. Looks like you're moving through that. Have you had a chance to look at that bill?
I looked at part of it, just a couple notes.
Sure.
I think one of the things, some other things that are in here, which would seem reasonable, but I think it's important that you would designate. I think you kind of have to look at there's several.
Oh, can you light up your mic?
Thank you. Starting over again, I think there are several categories of executive orders that you have to distinguish between if you're going to step through and do this. And I'll just give you a couple of examples. One of them is, the first one is the easiest one to deal with, and that's probably orders that are simply and truly just orders regarding the executive branch of government and the administration of items within the executive branch of government. I'll give you a couple of examples. And this has to do with one of the things is one of the things in here, one of the things in the bill says that every executive order should have a beginning date and an ending date on it. Sounds reasonable, but here's a couple of examples where that may not be quite accurate. For example, just recently this year, like a month ago, the governor issued an executive order about what the approval process is for foreign travel being generally considered and defined in the executive order as travel outside the continental United States. So anytime any member of the executive branch only, doesn't apply to the legislature, doesn't apply to the judiciary, anybody who's traveling outside, there's a process that we go through. That one of them is you have to tell us where you're going, what you're doing, why you're going there, and how long you're going to be there. Then once that comes in, then that goes to that is reverted over to Homeland Security, who then examines what is the organization sponsoring, who is it that's sponsoring that event, what are their ties, what are their background. They bounce it in through what's called the Fusion Center, which has both federal Homeland Security as well as FBI and other contexts in there, where you look at that information, see if who is this, who is behind the organization, who's hosting it, does that create a problem, a potential embarrassment or security risk for Wyoming. Then also they look at the foreign travel restrictions that may be applicable in that country, so that we can identify whether or not you send people there. If there's particular political or civil unrest happening in an area that may also affect the foreign travel and the approval for the foreign travel. So that goes into effect, and there wouldn't be a reason that you would have a termination date on an order like that. Others others that are kind of terminate. Another example is the governor by orders created the CARE team, which is a cybersecurity emergency response team that goes out. And so when you have, and you may have known about some of these in a certain towns in Wyoming, certain hospitals in Wyoming, certain counties in Wyoming have had cyber intrusions. And so ETS has a statewide response. And so there's a CARES team, which is a combination of everything from DCI, it loops in the Wyoming ETS, the Wyoming Homeland Security, and helps involve the the Fusion Center, which again is the sharing of intelligence across both state and federal agencies to respond to those types of cyber care incidents. That's not in statute. If you put it in the statute, you wouldn't necessarily need it, but why would you put a termination date on the CARES response team? So those are just a couple of examples of why you wouldn't necessarily want an ending date on every executive order. Others that would kind of terminate by just natural and would make every sense to have a termination date on it is the governor by executive order created the Wyoming it's not the Sesquicentennial, it's the yes, thank you. It's that one. So he created that. Obviously, that celebration, I believe, happens in 2025. And, 2026, 1776, of course. So anyway, 2026. So that will, that will terminate when that's done. So obviously, and I think that one does have a termination date in it, so to speak. And then a lot of the others are then another category, which is a little bit different, are emergency executive orders. And those come from several places. Sometimes there's just a general executive authority. The governor declares an emergency. Sometimes they come out of statutory authority, such as the public health emergency orders. And sometimes they come out of federal statute. Sometimes they come out of state statute. There's some executive orders that are authorized in the livestock arena. There's some executive orders that are authorized, like say in the transportation that come through the Federal Highway Department. So those, and most of those have limitation dates on, they expire generally within 30 days and they can be extended, but you have to demonstrate that the emergency continues. And then again, emergency EOs, oftentimes there could be, they should terminate at the end of the emergency. Once the emergency there, the executive authority to act in an emergency is gone. And so sometimes in going back and looking, we found that we might not have been as in some declarations of emergency. We've done some with over the years with particularly bad weather incidents, fires, flooding in Yellowstone National Park a few years ago that had us plowing roads in other places and doing some evacuation in Yellowstone National Park with those. Buying roads in another state because that state couldn't get to where they could plow the roads, some things like that. So there are some executive orders there that again have emergency, and they go away when the emergency goes away. And you don't have that executive authority once it goes away. Again, some of those are in statute, but what we could do a better job about is that we noticed in going back and reviewing all those orders in preparation for this testimony is we haven't always been consistent in declaring the state of emergency ended. Sometimes it's obvious when the snow melts, there's not an emergency, but that's one thing that we could get better at is declaring when the emergency is over so that there's no question when the executive authority is done. And then I think the third category is when you have ones that are implementing a policy and directing the executive branch to do things, which are the examples here would be the sage-grouse executive order or the migration order, that those things as they go out, I think that those are unique. And again, I think usually when those things come out, it's in relative response because there's usually some federal action or there's something pending that seems to require that type of action. And I think that, again, publishing those things, maybe having requirements they be delivered and I think they are delivered to the Secretary of State and the Attorney General, but again, there's no specific statutory requirement where they should be filed, where they should be housed. you'll find as you go through and look at some of the materials that Ms. Sharp put together in preparation for that. She went back and reviewed the NCSL documents and some of that. You'll find that some places, for example, if there's a reorganization, we talked again about ETS, we talked about HR. If there's that type of reorganization, you'll find some places that there's a requirement that that be reported to, and that reported that, and then ultimately there's a few states that have put a requirement on themselves that they have to take action on that reorganization within the first X number of days of the legislature. Otherwise, the executive order continues on. So there's some ways that you can go about and look at that. I mean, right now, there is not a formalized process. I think in doing that, if you're headed in that direction, we'd be more than happy to work with you. But I just wanted to make the point that I think you have to be, there are different levels and different categories of executive orders, and they shouldn't all be treated the same. They're not all the same.
Any other questions for Chief Perkins? We're nearing close to that 1 o'clock time, so everyone's real quiet. You have something, Senator Scott?
General comment if you're ready for that.
Well, let's take public comment first and then we'll do that. Do we have any public comment? How about online? One? Let her in.
It's like 3 monkeys right there.
Speak for yourself.
Pretty scary, isn't it?
Hi, are you able to hear me?
We can hear you.
Okay, great.
And now we
So-
can see you.
Great. Thank you very much, Chairman. First, I want to apologize. I keep forgetting to introduce myself. My name is Carrie Agan. I'm a geoscientist. I'm retired from the Bureau of Land Management as a geologist. I would like to make 2 particular comments on executive orders. First, because I worked for the Bureau of Land Management, I also worked on the resource management plan for the Buffalo field office, which is where I worked. So I have a familiarity with the workings and effects of the sage grouse implementation team, SIGIT. I would like to take this opportunity to remind everyone that sage grouse protection is all based upon what's termed a biological opinion. This opinion is, of course, an opinion. Yes, it's based on counts of actual birds and leks, but it's expanded from there to include probable birds and probable use of leks within a certain amount of time. Since I worked for the BLM does not manage the bird itself, but its habitat. It's what's called an obligate species. It's considered an important species, an indicator species, because it indicates the general health of various other sagebrush-dependent species. This threat that the bird might become listed as endangered is just that, a threat. And as Governor Gordon's chief of staff indicated, that threat has been going on for about 18 years now. As the bird has not been listed, nor is it even close to becoming so, there should come a time when the real threat, which is to our economy, our businesses, our roads, and other infrastructure, and property owners and lessees' rights need to be considered to preclude a biologist's opinion of a bird's potential for listing as endangered. When will that point occur? How long will the governor continue to deny property owners and lessees their due, full, and legally obtained and held rights over an opinion, and an extremely flawed opinion at that? 20 years, 25, forever? My second comment has to do with COVID emergency. It was known by early 2020, earlier than that, in fact, that COVID was not the killer it was made out to be, yet Governor Gordon kept in place emergency orders to keep everyone locked down and masked up and various things like that. I apologize, I don't remember all the particulars of that, but he kept the emergency in place for quite some time after it was very clear it was unnecessary. So as the last speaker just spoke about, I think that was the speaker his chief of staff again, that there need to be time limits, and there needs to be also recourse if the governor is believed to be continuing these EOs or emergencies for an undue length of time. Thank you very much.
Thank you, Ms. Agan. Committee, do you have any questions for Ms. Agan? All right, we appreciate you joining us again.
Thank you very much. I feel very privileged to have been able to testify this many times today.
Yeah, you bet. We enjoy public comment.
Thank you.
Okay. Any other public comment? No? Okay, we'll go ahead and close public comment. Committee, Senator Scott.
Mr. Chairman, couple of general comments and winding up with a question for Perkins. When you look at the separation of powers, Madison in the Federalist Papers spoke of the need of each of the three branches to defend its powers and prerogatives, and said we had ample means to do so. Now, he was speaking of the initial federal constitution, which we've all imitated. And I don't see a problem here in executive orders. And as I read the material from the LSO, the courts ruled very clearly that they couldn't be used to establish law, which would be the real way that abuse could creep in and cause us trouble. And frankly, I don't see that. And Mr. Chairman, one of my rules of legislating that I've stood me well over time is if it ain't broke, don't fix it. And I think that applies in the general subject. I don't see it being broken. That having been said, if the executive branch has some particular things they'd like to see done, whether they really would like to see a requirement that the orders be compiled and listed at the Secretary of State's office, that'd be a bill we could do. We could also, if they're having trouble with counties that were at variance to the executive orders, and I'm thinking in particular some of the sage grouse and migration orders, if that's a real problem, we could give them the option for doing, if they chose, an executive order as an emergency or under the general rulemaking provisions. That would give them some more force in dealing, particularly with counties and cities. But I don't see any need to do that unless the executive branch thinks there's a real problem there. So, Mr. Chairman, I would see those as the options and would urge us to pursue them only if we're asked to.
No, you spoke about the depository with the Secretary of State's office. That seems like an easy lift for us.
I haven't talked to the Secretary of State about that, but he is a filing office, and every other rule, every other statute, every other enrolled act, everything that that has that force or effect of law, that's where they go, and that's where the database is. So it would make, obviously all that stuff's also at the state library, but that's where people go when they want to look at those things, is usually the Secretary of State's.
Any other general comments? Everyone generally okay with, at a minimum, if that's what we do with the Secretary of State's office? Everyone seems pretty okay with that.
And Mr. Chairman.
Yes, Mr. Co-Chairman.
So, Mr. Chairman, I think I track with understanding that if a citizen or someone wants to challenge an executive order, that it kind of, that path sort of depends on the order itself in a way. And that if there's underlying rulemaking or actions of agencies in compliance with the executive order, a citizen could challenge the authority of those agencies. I sort of get that. And I think that was the gist of what Chief Perkins conveyed in that, but is that the only redress? Is there more direct redress available? I mean, for example, injunctions, I don't know, but is that to help citizens understand the context of executive orders and their rights as citizens? I think it might be useful to understand that better.
Chief Perkins?
Thank you, Mr. Chairman. Mr. Chairman, Senator Case, Chairman Case, it's been a while since I practiced administrative law.
Yeah.
But I believe that, again, what happened, first of all, whenever you challenge anything, you have to be, the first question is you have to be administrative, you have to be a aggrieved party.
Yeah.
And if you're a judicial review, you've got to have standing, and standing's gotten tricky in the courts. At least in my experience as a lawyer, standing's gotten trickier and trickier. Courts look at that much more in depth, and there's been some, I think for lawyers, we've seen a few twists and turns in that area that may have been unexpected. But yes, there are several ways. First of all, again, anytime an agency takes an action and makes a determination. So if the OGCC or somebody has taken, for example, OGCC makes a determination on a drilling permit or a requirement with respect to something that's in the core area, that's a final administrative action. That court has two things. They can challenge that administrative action, which I believe would get them. I think that those go to the OAH. I'm not an oil and gas attorney, but they would typically go to the Office of Administrative Hearings. I think the same thing there. If there was a requirement, if the Game and Fish Commission, if they made a final determination that affected your property in some way with respect to habitat, or if one of the 5 electeds in imposing restrictions on state lands, then have by rule or by action made a determination that affects you, that then spills over and affects you adversely on your private land, again, you have the ability to challenge those things through generally the Administrative Procedures Act. If you don't, the other thing with executive orders are you can always go straight to the court with respect to, has the governor exceeded his executive power in issuing that order? That could be, has he issued an order where the legislature has already spoken and indicated either that you could or couldn't, or exceeded the power because the legislature hasn't done that, or it's just exceeded the ability and he's moved over and away from policy and has somehow now made law in one of the very specific ways the Constitution allows the governor to make law. Those are very limited. Typically, an example is line item veto. When he scratches out a word, he is now changing the law. So he is making law in that respect. But again, that's very, very constitutionally specific. There's no way for him to make a statute override an existing statute. So if he's exceeded that power, he can go directly to the court. And when you bring that action to the court, you can then seek typically you seek a TRO, a temporary restraining order. Then that's later set for a preliminary injunction, and it may or may not be a permanent injunction depending on the outcome of the litigation itself. And so those things are all available to citizens or businesses or others who are affected by those executive orders as well.
Thank you, sir.
Representative Knapp.
Thank you, Mr. Chairman. Just a comment. I think this is something we certainly don't go forward with, and the good senator's comments about citizens reminded me of this. When we deal with rules in agencies, which I view the sage grouse as part of that, rules are driven by statute. Rules are driven by the legislature. They're guided by the legislature. And very seldom do you have an agency that comes up with rules that don't fit to one of those pieces of legislation. What this, in effect, guides us towards is the power of policy residing in one man or woman, but the power of policy residing in one entity. And I think the Constitution, as Mr. Perkins so eloquently put, grants the authority to the executive branch internally. So the executive branch can be in charge of their own agency, if you will, internally. It does not give the authority to go externally and implement policies that are not driven by state legislature. And so even as it comes to emergency policies, those are granted by the legislature. And we made that very clear with what happened with COVID, aftermath of granting that authority, but giving it within reason and involving the legislature to come back and basically codify that. So I think that the Constitution is clear, and to muddle the waters with it would result in a citizen having to have a lawsuit of being infringed. And I don't think that's where we want to head. I think that we want to maintain a clear indication of what the Constitution states. And as Senator Scott said, don't fix something that's not broken.
Committee, any other general comments? Thoughts? We're good to go. We got the one direction for the one little simple bill. Depository. I think that should, in my opinion, tell me if you think differently, but I think that bill needs to specify that those should be posted on the website as well. You can access all the rules online. You should be able to access so we should give that, I think, specifically direct that. Available to the public, yeah. Yeah.
Is it clear that we're talking about all past executive orders, or is going to be current as going forward? I mean, there's probably a research issue on older ones, but it might be interesting to find those. So I'm not sure what we're really asking about the body of previous executive orders. I'd like to see the one about the Johnson County War, actually.
Yeah. It sounds like they're all available in the library right now, so
If they're all available, let's get them.
just a matter of moving them over to a different platform. I'd say we do them all. What? Sorry. Staff?
Mr. Chairman, during my research, I found that most of the executive orders dating back to the 60s are with the state library.
Okay, so
Not all orders.
Yeah.
the Johnson County War is not gonna work. All right. Well, we'll go back as far as we can, I guess. I don't know how you put that language into a bill, but whatever can reasonably be found and identified shall be added to the depository, something like that.
Is there a point that executive orders don't have any force? I mean, there must be some kind of expire because of what they say and what they're about, and some may have a hard expiration date, I suppose, but that'll be kind of interesting. Our research will find more.
Mr. Chairman?
Yes.
And you find that, I think you can even find old rules, expired rules. I think you can find the old rules are also on the website. So I think they have the proposed, they have the temporary, and it seems like they have the expired rules on the Secretary of State's website too. So I think there's a way that you can differentiate though. But you're right, most executive orders have a
Context.
You have a context, and they have the ones that happen the most frequently are these ones on propane delivery, and they expire by their own. They can only go for 30 days.
Yeah.
And then they expire. And so, and most of them are like that. Like I say, most of the orders are emergency orders. And so, like I say, we could be better at determining designating when an emergency is over. But typically, if, for example, when the flooding stops in Yellowstone, the emergency is over. So, yeah.
All right. Mr. Co-Chairman, do you want to go through staff directives, or do you want to do that in just a meeting between us?
I think it'd be pretty short if we just maybe get a read back from Katie and Josh, what they think we told them.
Except for the housing, we might be here an hour.
Yeah.
No, I have it. We have it,
She's
Mr.
got it.
Chairman.
You got it? Okay.
Yeah, Mr. Chairman, so beginning with housing, we have a bill to resurrect House Bill 216, preemption of landlord tenant law.
We have a bill regarding regulatory reduction that's aimed at restricting excessive local regulations. We have a bill to draft a new version of House Bill 221 regarding legislative designated investments. We have drafted a bill regarding use of government lands and state lands for housing. We have a resurrect of the Sherwood Furphy bill about abandoned nuisance buildings. We have a bill regarding tax increment financing to add an affordable housing piece to that statute. We also have research regarding TIF in other states, including states where they use affordable housing as a trigger. We have a bill to specify that in the list regarding TIF, we need 4 of the 9 conditions. We have a bill, I believe, from Representative Yin regarding the condo on government land issue. There was a request for either a bill or research, I think maybe on an individual becoming a tenant after 72 hours. Moving on to
I
electricity.
think just research on that one.
Okay, we'll keep that to research. Regarding electricity, there was a request for a bill to allow municipalities to put solar panels on their own property and own that. That came from the chairman. I'll go over a couple of the working groups. So regarding the Wyoming Telecommunications Act, the industry representatives who testified plan to meet regularly and bring legislation or ideas to the August meeting. And they welcome participation by members of the committee. Regarding 911, the committee requested that YDOT come up with some language for the next meeting and share that in advance with members of the industry. And then also requested that YDOT research laws in other states and PSAPs. Regarding LLCs and business fraud, the committee decided to form a working group to address the registered agent issue. That will include assessors, Secretary of State's office, and some committee members. And then there's a bill to mirror the administrative dissolution provision in the LLC statutes in the trademark and trade name statutes. Regarding insurance, this morning we had the bill to incorporate the Department of Insurance accreditation bill holding company changes. We have a bill draft to incorporate the Department of Insurance cleanup bill. We have a bill draft to incorporate those items that are not part of the cleanup bill. And the Department of Insurance will get LSO a draft of that towards the end of June and early July. And then we just had the executive orders in Wyoming Administrative Procedures Act. So we're going to make the Secretary of State's office the repository for those executive orders.
Sure. Mr. Co-Chairman.
I think that was very good. That was excellent, kind of the way I remember it. With regard to the kind of the LLC fraud, that kind of working group, Mr. Chairman and members of the committee, I don't care if we do it as equal partners with the Secretary of State's office, for example, in terms of organization. I think we should have kind of standing and representation as our own branch and the committee in that process. So I definitely would look to volunteers from the committee or maybe to contact the chairman and Mr. Chairman, you'd be excellent on that with your background in corporate law. And I don't know that I want to push you into that. But others welcome their participation.
I know Representative Ottman wants to be on that.
I got that yesterday. Yeah. There's no pay. So it's just, I'd probably be Zoom meetings and connecting with these people. So I don't think there's actually a limitation on number of members that would want to be on that if you wanted to serve in that manner. I just think in the end, might be a joint working group with the Office of the Secretary of State and the industry, not under the direction of one entity or the other necessarily. Thank you, Mr. Chairman.
All right. Anything else, committee? If you want, yes, Senator Scott.
Chairman, on the housing regulation limitation bill, would ask leave of the chairman to give the LSO 2 additional provisions. One, limiting the fees that the state and local government can charge to the cost of creating and implementing the permits involved and not use them as general revenue raising provisions. And second, allowing our owners to obtain building permits and not just restricting it to general contractors the way one of the counties did. So if that's all right, I can write that up and submit, give it to LSO.
Looks like they got it. We'll use that as a starting point.
Okay.
That's fine. Okay. Anything else, committee?
Good
All right.
meeting, Mr. Chairman. Good job.
Look at that. It's 1 o'clock. We're an hour ahead of time. We are adjourned.
Thank you. Good job.
Good job, you guys.
Everybody drive safe.